Yep, we're good.
I declare open this hearing of the Senate Economics Legislation Committee into inquiry into the Financial Accountability Regime Bill 2022 provisions, Financial Sector Reform Bill 2022 provisions, Financial Services Compensation Scheme of Last Resort Levy Bill 2022 provisions, and the Financial Services Compensation Scheme of Last Resort Levy Collection Bill 2022.
Yep.
I begin by acknowledging the traditional custodians of the land on which we meet and pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander people here today. The committee will be conducting today's hearing via video conference, teleconference and in person. These are public proceedings being streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. The Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Commonwealth officers appearing today are also reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised. A copy of the order is available from the Secretariat. I remind committee members and witnesses who are appearing via video conference and who are not speaking to please mute their microphones. I now welcome by video conference representatives from the Financial Services Council. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today?
Thank you, Chair. Spiro Promidis, Executive Director, Policy and Advocacy, Financial Services Council.
Good morning, Senator. Bianca Richardson, Policy Director for Investments and Global Markets.
Morning, Chair. Ashley Davies, Legal Policy Manager.
Good morning, all. I now invite you to make a short opening statement, and at the conclusion of any remarks, I will invite members of the committee to ask questions.
Thank you. The Financial Services Council welcomes the opportunity to appear before this committee into the proposed compensation scheme of last resort and financial accountability regime. The FSC submission referenced our previous submission to the Senate Economics Committee in December 2021, which, in relation to the financial accountability regime and compensation scheme of last resort provisions, were largely in the same form as the bill presently being considered by the committee. On the compensation scheme, we have provided a few additional comments in our submission to this committee, including the need for the scheme operator to use reasonable endeavours, not just have the right to pursue recovery under subrogation rights to reduce overall scheme costs. We think that this should apply to backdated claims, and any funds recovered should be returned proportionately to the 10 banking and insurance groups funding the backlog of accumulated unpaid claims. However, overall, we think the government is right to take a cautious and prudent approach to the final design of the scheme to mitigate any moral hazard risks. The essential features of the scheme, in our view, are correct, including the $150,000 cap on claims and a focus on individual advice failures. The scheme needs to be well designed and sustainable. We support the targeted scope of the scheme, which goes beyond the Ramsay recommendation of covering financial advice. Our industry recognises that consumers are impacted by financial advice failures and often incur significant losses. But at the same time, this must be balanced with the fact that companies funding this scheme will take responsibility for the quality of their advice and do not contribute to unpaid claims. Having considered the various arrangements for increasing coverage and increasing caps for the scheme, when the previous bills were referred to the committee, it was recommended they pass, recognising that the scheme correctly balances the liability for industry, the provision of just compensation of claimants for the scheme contributors, and restoring consumer confidence in the financial services sector as a whole. Our collective goal should be a compensation scheme that is rarely required, which is why we separately continue to flag the need to consider other regulatory settings in parallel, including appropriate capital and professional indemnity requirements for financial service providers. On the accountability regime, we do have some technical comments, but on balance, we think these technical points should not disrupt the passage of the bill. Thank you again for the opportunity to appear. We're happy to answer any questions from the committee.
Thank you so much for that opening statement, and I might just kick off with a couple of questions, starting with the FAR. The banking industry is currently subject to the Banking Executive Accountability Regime, the BEAR. Based on your experience with that, what are your views on the expansion of the BEAR through the financial accountability regime to other sectors, including super and insurance?
I would just flag that at the onset of that question, Chair, that the Financial Services Council represents financial advice licensees, superannuation funds, fund managers, and life insurers. And so we don't have any existing experience with that regime. But that being said, we definitely have views on the appropriateness of the expansion. And I'd pass to my colleague, who's a resident expert, Ashley Davies.
Thank you, Chair. Thanks, Brew. Yeah, look, I mean, I think that the form of the bill is broadly in a form that we are supportive of generally. We do think that there are we expect technical issues regarding the drafting that need to be changed, because we think that as drafted, there is likely to be an unintended overreach where the bill captures foreign entities and indeed other entities that are not involved in financial services businesses. And I think that this can be fixed essentially by way of drafting changes to the legislation and the ministerial rules. But I think as a group, we're broadly supportive of the overall framework.
Okay, thank you. And in relation to the overall framework, and as it applies to your members, how will the increased scope of the FAR help to restore confidence and trust across the sector?
Yeah, go on.
Sorry, thanks, Ashley. Well, I think kind of the point of the regime is to hold entities and executives to account. And so kind of when you look at the regime, it kind of has a set of core obligations. It's got accountability obligations, which require entities in the banking, insurance and superannuation sector and their directors and most senior and influential executives to conduct their business in a way that is honest, with care, skill and diligence. It's got key personnel obligations, so that accountable entities have to nominate senior and influential executives to be responsible for all areas of their business operations. It has deferred remuneration obligations so that the incentives are appropriately correct, and it also has notification obligations. And so overall, the intent of the regime is to make and then obviously it has penalties that attach, and so that changes the incentives of executives and and management in the industry. And I think that's a positive development, and it will sharpen the focus of the industry and going forward.
Okay, thank you. You referenced in your comments there the deferred remuneration provisions as an accountability measure. There's also been some submissions to the effect that the FAR should include penalties that are not currently in the BEAR and that were not recommended by the Hayne Royal Commission. How do you see the legislation, balancing out those interests? Do you think that expanding the FAR to include civil penalties for individuals is necessary or appropriate, or do you have a view around the deferred remuneration provisions being effective in guiding behaviour?
Well, I think in terms of the penalties, we're of the view that the ancillary civil penalty provisions included in the draft bill strike the appropriate balance. We recognise that there was some debate in the past regarding the contents of the bill, but I think it's important also to recognise that the existing corporate legislation and common law framework does already contain a number of provisions which are going to directly impact the individual liability of senior executives and particularly directors. So I think our view is that the bill strikes an appropriate balance. It does include additional civil penalties, but there are already a large number of provisions in the existing legal framework which do capture senior executives already. And so our view is that this is an appropriate addition to the bill.
Okay. I'll just come to your comments on the compensation scheme of last resort. Just in a general sense, in line with the recommendations of the Banking Royal Commission, the bill puts responsibility for funding the compensation scheme to industry with a levy. You've made some sort of technical comments about some of the operation of that, which I'll come back to. In a general sense, are you supportive of industry funding the scheme?
I think we've accepted that that's the approach that's being taken, and we're supportive of the bill as it's currently drafted, passing Parliament. So, in that sense, yes.
Okay. And then you've talked about the need to consider professional indemnity insurance and the availability for the scheme operator to be able to pursue insurance claims to recover costs. And you've talked about that in your opening statement this morning as well as in your submission. There are, steps which AFCA and the CSLR are required to take to try to ensure that entities pay compensation that's owed and ensure that no other scheme is available before going to the CSLR. Why is it that you think there needs to be some tightening there in the provisions?
I might pass to my colleague Bianca Richardson in a moment, but I think kind of at a high level, just when it'd be useful to just have an understanding of how professional indemnity insurance currently operates and some of the limitations around those policies, because the fundamental kind of initial regulatory setting is that Australian financial services licensees have a license condition to have appropriate professional indemnity insurance to ensure that if something does go wrong from a customer interaction sense that they can be compensated through that mechanism, but there's a few kind of gaps in the regime that are probably worth highlighting.
Yes, in addition to that, so in terms of the professional indemnity insurance, it may be the case that the advice licensee doesn't have sufficient capital to pay the excess on the claim. And if the advice licensee doesn't have the capital to pay the excess on the claim, then that might be one of the reasons that the insurance policy doesn't pay out. And so one of the things that we would encourage is that if an entity goes into voluntary administration, for example, that to ensure that the scheme is genuinely last resort, that the scheme operator uses those subrogation rights that it has, and then also seek to pursue recovery under the professional indemnity insurance where it's appropriate to do so. So, for example, there's one of the reasons that it might not pay out is because there's no capital for the excess. Another concern might be that in relation to when an entity becomes insolvent, there might be an insolvency exclusion under the policy so that the policy no longer pays out under an insolvency. So in that instance, for example, it would be important for potential claims to be notified to the insurer before the financial services entity becomes insolvent, so that those claims are registered under the policy while it is still active. So those are some of the comments that we would make around tightening PIs so that the PI policy has the ability to respond, and so that the scheme becomes genuinely last resort to then pick up claims that the PI policy doesn't pay.
And if I could just to close that out as well, I think kind of ASIC has regulatory guidance in Regulatory Guide 126 for compensation and insurance arrangements for licensees. But I guess the point that we would make is ASIC can't, obviously, and we acknowledge that ASIC can't review every area of the law and compliance with every area of the law, but we also kind of question whether they are doing enough to question whether the licensees have adequate policies in place, given some of the issues that my colleague has raised.
Okay, thank you for that. Before I hand over to Senator Bragg, who has a couple of questions, this financial accountability package has been around for a while, with previous legislation in the Parliament and various consultations. You've said that you're broadly comfortable with the package, and you're giving us additional advice as to some of the technical aspects of implementation that you'd like us to review. Can I just clarify that you're broadly supportive of the package passing and passing reasonably expeditiously?
Yes, I can say that unambiguously that we support the legislation as is, unamended, passing the Parliament. Notwithstanding some of the technical comments around the FAR, we think that there might be other mechanisms through regulations to deal with some of those issues as well, and there are ongoing consultations on those issues. So, yes, we do support the passage of the legislation.
Thank you so much. Senator Bragg.
Thanks very much, Chair. I have a few questions for you about the moral hazard issues here and also the ongoing funding of this organisation. So firstly, how would you characterise the moral hazard risks here of establishing a scheme which may incentivise the regulator to do less work than it's doing today?
I think there's a couple of moral hazards that come through this scheme, and just to unpack that, the first one that kind of comes to mind is consumers potentially not taking enough precautions to make sure that they're dealing with a bona fide and reputable financial services provider and advisor. There's the moral hazard of the parties that could conduct fraud. And then I guess to your point, Senator, there's also the moral hazard of the regulator that they might not do as an effective as job on enforcement because of the fact that they could just allow claims to go through to the scheme, so they could and so those are probably the three kind of main channels that have been identified.
And do you think that that moral hazard issue, particularly the latter moral hazard in relation to ASIC, which has already got its own set of issues, has been addressed in this bill?
I think that that's a challenging area to address, and that's kind of why, in particular, we raise issues around the regulation of professional indemnity insurance, which, in our view, may already be lacking, and so there's already some areas of the law where we think ASIC could of enforcement where ASIC could sharpen its focus, and I guess we don't see how that will occur under the current arrangements.
Okay, so you don't think that risk has been addressed in this bill?
I think that we're of the view that the bill creates a lot of moral hazards, and you've got to make choices about balancing those risks, and the bill does the best job it can, noting that the bill creates risks in other ways because it's an intervention.
Okay, so what about moving to your membership? How many AFCA determinations has your membership group received?
I wouldn't have those figures on hand. We wouldn't analyse that, but I'd say that our members are all have internal and external dispute resolutions, and would all be subject to many would have AFCA determinations and would have paid them, and we wouldn't have any members with any unpaid AFCA determinations.
Okay, and so when your members receive an AFCA determination and then they subsequently go out of business, or there's some sort of major event, it's in that circumstance that there would be effectively the access to this scheme.
The way that not focusing on our members of any financial service provider that would have a determination against it, that then subsequently goes insolvent, would and provided that the client, it's a determination for an area covered under this scheme, they would be eligible to go to this scheme. Yes.
Okay, and in terms of the funding of AFCA, are your members providing funding to AFCA?
That's correct.
Yeah, and what do you think of the funding mechanism that's been proposed in the regulations?
As I said, we're broadly supportive of the legislation as it's currently.
That's not in the legislation, that's in the regs.
Certain elements of it are in the regulation, Senator. That's correct. And so we've put in a submission on that, but I'm not sure whether that's the subject of this inquiry.
It's very hard to separate the issues here. We're looking at legislation and regulation on the same matter. So the question of how this body is funded on an ongoing basis is impossible to separate. I mean, this
On an ongoing basis, we're supportive of the funding arrangements.
And so, and how do you imagine? What is your understanding of how it will be funded on an ongoing basis?
So the way that the scheme works currently is that the individual sectors that are subject to a determination it's a very complicated funding model to explain, Senator, so just bear with me as I try and work through it. So for each subsector, there's a $20 million cap. And so claims that get attributed to that subsector up to that subsector are allocated to that subsector. And so, for example, if there was $10 million of unpaid determinations in financial advice, then the financial advice sector would pay $10 million. If there was $25 million of claims, then the minister would have to, for that $5 million element, make a determination of how to allocate that extra 5 million, and would be subject to ministerial discretion.
Okay, so the minister decides on the funding allocation.
For claims above the initial $20 million cap, yes.
And how many subsectors are there?
4.
And what are those?
Financial advice, securities dealing, credit intermediation.
They've summarised it as credit activities, but I believe it covers 2 areas of credit.
What's the last one?
So there's two within the credit.
Oh, credit, right.
Yeah.
So what is it? So it's advice, securities and credit?
Yeah.
Okay. And so the minister can decide how to allocate funds above that?
Above 20 million, up to a cap of 250 million.
Because the reason I'm going down this path is, of course, if the Parliament enacts this bill and grants the minister this power, because the power's in the bill, isn't it?
That's correct.
Right. So if we grant a minister of the day this authority, then they are going to be able to issue levies into the industry in order to pay for various things that happen. Now, if I take you back to your initial testimony about the moral hazards, I would have thought that we're granting godlike powers here to a minister.
I think that we would agree, and we've put in a submission on the regulations, that there could be more that could be done to make it clear how that discretion will be utilised, or to put principles around how that.
Yeah. Is that in your submission on the regs or the bill?
On the regs.
All right. Well, can you provide some of this on notice?
Yeah,
Because,
happy to provide that submission on notice.
I understand that there are certainly circumstances, this is just for the record, I don't want to take any more of the chair's time, but I understand that there are certainly circumstances where there has been phoenixing-like activity and it's been very difficult for people to get access to appropriate compensation. But we are opening up and trampling on certain principles that have existed for a long time to try and prevent moral hazard. So in relation to the granting of funds and the levying of funds, I think that is potentially where the greatest moral hazard lies within this package, which has been separated between bill and regs, as we've discussed in your testimony. So, yeah, can you provide that on notice? And is there anything else you want to say on that matter?
Yeah, happy to provide that on notice, Senator. Thank you.
Thanks.
Was that the end of your question, Senator Bragg? Thank you very much. I think we've reached the end of our time. So thank you so much for appearing as witnesses today, representatives of the Financial Services Council. The committee has agreed that responses to questions on notice should be provided by COB Monday, 17 October. And I'd ask that you now disconnect from the hearing, and if you'd like to continue observing, if you'd like to do that, you can do that through the live stream on the Parliament's website. Again, thank you very much for coming today.
Thank you.
Thank you.
I now welcome by teleconference the representative. I now welcome by video conference the representative from the Australian Banking Association. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
Good morning, Chair.
Good morning, we can hear you. Yep. Miss Cupit, we have just lost you. You're back. Have another go. Yep.
Christine Cupit, Chief of Policy and Strategy at the ABA.
Great.
And Chair, if the connection becomes a problem, I can join by teleconference.
Yes, great. We've got you at the moment, and that can be our fallback plan. I now invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Thank you. So thank you for the opportunity to appear today and discuss the banking industry's support for the financial accountability regime and the compensation scheme of last resort. The ABA represents 20 banks from across Australia, including the 4 major banks, iconic regional banks and international banks with an Australian banking licence. In the previous Parliament, I appeared before this committee on behalf of the ABA to express support for these bills. The ABA continues to support the passage of the 4 bills before this committee. The bills represent the final legislative reforms required to implement the government's response to the Banking Royal Commission and further improve trust and confidence in the banking industry. While supporting the bill's passage, we take this opportunity today to highlight some key points about each and propose a change to the compensation scheme of last resort bill. On the compensation scheme of last resort, the ABA is supportive of establishing a forward-looking compensation scheme that is industry funded, operated by AFCA, and has design features consistent with the recommendations of the 2017 Ramsay Review, which were later endorsed by Commissioner Hayne. In addition to the ongoing operation of the scheme, the bills provide for an upfront levy to meet unpaid determinations from complaints made prior to the day the bills were introduced. That date is called the Accumulation Recovery Day. The levy is to be paid by the 10 largest financial institutions whose total income exceeds $6 billion in an income year. The ABA is concerned about the design and estimated amount of the upfront levy and the lack of certainty as to the final amount. Fully understanding the exposure of these institutions and the operation of the upfront levy is critical to the proper operation of the scheme and for these institutions to plan for financial liabilities and understand the impact on shareholders. When the bills were introduced in the previous Parliament, the initial estimate of unpaid determinations to be paid through the levy was $19 million. The Treasury has since advised that the estimate of unpaid determinations may be as high as $250 million. This is a poor public policy outcome that undermines the design of the ongoing scheme, which has been developed to more fairly allocate to limit cross-subsidisation and require the subsectors that are responsible for the unpaid determinations to meet that cost. The ABA encourages the committee to consider the following proposals to improve the design and operation of the scheme. Firstly, the bill should revert the accumulation recovery date to 28 October 2021. This is consistent with the date the bill was introduced in 2021 and consistent with the government's objective to introduce the same legislation. Secondly, the scheme should operate as a true compensation scheme of last resort, with levy estimates covering claims that are reasonably likely to meet eligibility requirements. Thirdly, either the bill or the constitution of the CSLR operator should require the scheme operator to pursue all options to recover funds, including professional indemnity insurance, unless it is unreasonable to do so. The committee should also consider measures to strengthen consumer protections and governance to reduce the number of unpaid determinations in the first place. The scheme contemplates up to $250 million of unpaid determinations in each year. This indicates a much wider problem with the regulatory framework that should be addressed alongside the scheme, and I'm happy to provide further information on this point during the hearing. I note that separate to this inquiry, the ABA has made a submission to the Treasury on the CSLR regulations that are currently being consulted upon. In that submission, the ABA sets out views and proposals regarding the operation of the subsector caps and how special levies should operate. The ABA is happy to provide this submission to the committee. Finally, on the accountability regime, the ABA's view is that to ensure the full and effective implementation of the regime, we support a regime that is consistent with the recommendations of the Royal Commission and is modelled on the BEAR, enables clear identification of accountability at the most senior levels, operates clearly together with other licensing, conduct and accountability requirements, and is enforced and administered by ASIC and APRA. The ABA is aware of submissions to this committee advocating for changes to the penalty provisions in the bill. The ABA does not support these changes. our view is that the regime already includes significant personal consequences for those accountable persons, and that individual civil penalties would further distort the liability of finance executives against executives in other sectors. I'm happy to take your questions.
Okay, thank you so much for those opening comments, and I'll kick off with a few questions. Just in relation to the submissions that you referred to just at the end of your statement around around some views that there should be civil penalties applying to individuals as part of this package. Can you talk me through how you see the deferred remuneration provisions working to guide behaviour, and also just give us a brief overview of what you think the existing penalties are that you have said you believe are effective. You've just muted yourself. Thank you.
Thank you. So thank you for the question. In relation to the BEAR and now the FAR, the deferred remuneration arrangements are quite effective. They're also consistent with arrangements that have been implemented in other jurisdictions. And essentially over a 4-year period, short-term incentive and long-term incentive benefits are paid subject to the discretion of the organisation and based on the performance of the executive. So if the executive was to be sanctioned under the BEAR or the FAR, or was to be identified by APRA or is otherwise identified by that institution as behaving poorly, they will lose access to those incentive payments. And in some cases, the incentive payments can be quite significant. In terms of the other penalties that operate, our colleagues at the FSC also pointed out the Corporations Act arrangements that apply to directors and officers of companies. And then ASIC also has significant banning powers, which are available to it for certain kinds of misconduct.
Thank you. I did want to ask you some questions about the SACS review provisions of the bill and consumer leases. So the ABA has fairly consistently spoken out about the need for consumer protections across credit and loan products, and talked about the need for effective, responsible lending obligations for all forms of finance and credit. Are you broadly supportive of those provisions in relation to payday loans and consumer leases, and what's the basis for that support?
Yes, Senator. I know we didn't make a submission on this point to this committee, but you're right. Over about 8 years to various inquiries, we have made submissions supporting these kinds of reforms. The first reason that we support them is because, as you say, there should be consistent consumer protection no matter where you get your credit or financial service. And we would like to see the arrangements be consistent across the industry. The second reason is that the reviews that have taken place have identified in some instances, significant harm to consumers. So we welcome the reforms in the form that they are. We particularly welcome the concept of the small amount credit provider needing to make the credit assessment rather than operating under the rebuttable presumption. I think that is A, much more consistent with the rest of the industry, and B, will provide better outcomes on an individual basis. And I think we're delighted that this government is able to implement these reforms because, as you say, they've been discussed for about 8 years now.
Thank you. Does the ABA and do your members currently see in your own work the impact of the poor lending practices that have been well documented by small amount credit contract providers? Do you see that flow through to your work, and what can you tell us about that?
Yep. So each of our members has quite sophisticated and well-resourced hardship teams that help customers that are in financial difficulty. And some of that can include referrals to other services like financial counsellors. But the challenge that our members have is they help the customer with the debt that they have with that institution, and as best they can kind of take into account other debts when working through hardship arrangements. But when those debts, are significant and, fall under different interest rate and repayment terms, it is difficult to negotiate hardship arrangements with those customers. On that point, the major banks and now a number of ABA members founded a charity called Way Forward Debt Solutions. Way Forward works with customers that have multiple unsecured debts to work through a repayment arrangement across all of those creditors. So we've definitely recognised the problem in dealing with multiple creditors, and that is one way that we help ABA member customers in that regard.
Great, thank you. Just before I turn over to other senators, I note the comments that you made about the design of the CSLR in your opening statement, and we'll have a look at those views that you've outlined there. At a general level, are you supportive of that the CSLR be industry funded in general, and B, are you overall supportive of this package of reforms that's been debated, discussed, consulted on over the past few years?
So in terms of industry funding, we do believe that is the correct approach. But the industry funding design needs to be appropriately designed and moderated to ensure that the sectors that are responsible for the conduct and in control of improving practices are responsible in the main for making the compensation. If you have participants from other subsectors, like just say it's a financial advice issue and you're asking APRA-regulated banks to step in and pay for it, those banks have no ability to control the conduct. So they've got and then the financial advice sector has less incentive to improve practices and stamp out poor conduct. So we've really got an incentive problem unless that those sorts of settings are appropriately calibrated.
Can I just ask whether you support the measures whereby if a CSLR operator has had to have a claim paid out on their behalf. So sorry, if an entity has to have a claim paid out on their behalf by the compensation scheme of last resort, that entity must have their licence cancelled. Do you see that as a useful measure in terms of some of the problems that you're raising there?
Oh, it's absolutely useful and it's absolutely necessary to prevent that provider from continuing to operate. And, some of the other measures that have been introduced to reduce the risk of phoenixing are also very welcome. But that's kind of the ambulance at the bottom of the cliff. Whereas what we're talking about is incentives to improve practice in the sector to avoid the poor conduct and then avoid the unpaid determinations.
Okay, thank you. And just broadly, I think the ABA is subject to the submissions that you're making today, broadly supportive and has been broadly supportive for a long period of time for this package of reforms.
Yes,
Yeah.
yes. I should note, though, that we have made a submission on the operation of the regulations, and as Senator Bragg pointed out, it's hard to sort of separate them, but there are more substantive comments that we have on the regulations, and we can furnish the committee with those.
Okay, thank you. Senator Bragg, I understand that Senator Smith has... I see. Senator Bragg, you have the call.
Oh, no, that's okay. I'm happy to go after Senator Smith.
I think
If he's first.
the consensus is that you have the call, Senator
Oh,
Bragg.
okay. Well, sorry about that. Sorry.
Okay.
Righto, good. Look, thanks very much, Ms. Cupitt. I mean, what is your view on how the moral hazard here has been managed in this bill?
So I think I understand why people frame it as moral hazard, but I think that it's more about potentially incentives and making sure that there are the right incentives in place to improve conduct and also address poor conduct, particularly by regulators. ASIC has a very difficult job. But there are features of the compensation scheme which mean that the posture and ASIC's posture has been that this is not so much a scheme of last resort. And we saw that with the media release early on this year, where ASIC was encouraging customers to make claims with AFCA in order to potentially benefit from the scheme. So we would say that that's useful information to consumers, but is worrying in terms of what the posture is of the regulators in AFCA.
Can I just confirm what you're saying there? So you're saying that there's evidence that ASIC has been encouraging consumers to make claims to AFCA in advance of this scheme being put in place, is that right?
That's right, yeah. So,
That's
I mean,
right.
if I can continue just quickly, I mean, ASIC has a responsibility to have informed investors and provide that sort of information. But we would like to see a posture from ASIC which is about last resort, not sort of second or third resort.
Can you provide that on notice, please?
Yes, yeah.
Thank you. Yeah, I mean, the risk here is that the regulator might be further, well, I mean, your evidence is already that the regulator is already potentially being incentivised to do less work in law enforcement because of the potential existence of this scheme. So we'll take your information on notice. In relation to these godlike powers that the minister would have to effectively issue all sorts of funding notices, why do you think this has been separated between the bill and the regs?
I couldn't answer that, to be honest, Senator. Our view is that the ministerial powers have been or can be properly legislated, but we would like to see, I guess, a judicious approach to using them and a focus on ensuring that the subsector that is at the centre of the poor contact and the unpaid determinations pays the lion's share of the compensation.
Okay, so, but what can be done to reduce the moral hazard here of a minister, any minister who is given these responsibilities, working with a weak regulator to effectively obviate the need to regulate and enforce the law by issuing funding notices to the industry to bail out what should be law enforcement matters?
I probably wouldn't characterise it that way, Senator, but we have observed, as I said, the posture from ASIC that customers can potentially avail themselves of this scheme. But what is, I think, important in this context is that there is an opportunity for this committee to recommend some other measures that should and could be put in place to strengthen the overall regulatory framework and strengthen ASIC's powers here. So colleagues at the FSC referred to improving professional indemnity arrangements. That would include, in our view, ASIC being required to take steps to make sure that PI premiums continue to be paid if the firm is in administration. And also looking at, in a serious way, what the governance and cash requirements are for managed investment schemes.
Okay, but what point are you making in your submission on the regs?
So the point that we're making is that the Minister's discretion for the special levy should focus on the subsector that's at the heart of the conduct, as opposed to moving across the other three subsectors.
Yeah.
And then to also give the Minister discretion in other kinds of financial institutions into the special levy arrangement. So, for example, discretion to bring in managed investment schemes.
Okay, well, can you provide your submission on notice? Because I think it's only fair that the committee is able to consider that, given that we're being asked to consider basically what is a shell bill without much detail. And in doing so, can you please consider, as a separate matter, anything that can be done to reduce the risk of a enormous transfer of power into delegated legislation, which potentially expands the moral hazard here. Okay, and look, my last question is, I don't want to take any more time, is just in relation to the way that the body would be constituted. So am I right in saying that effectively the AFCA would have a subsidiary which would administer the funds, and that would effectively report to AFCA, is that right?
Overseen by ASIC, so it would have an independent board, and then the operation is also overseen by ASIC.
Yeah, and you think that the seed funding that's going into that, do you think that's is that right or wrong in your view?
We think it's very arbitrary, and we think it undermines the way that the scheme has been designed. So there has been an attempt in the scheme to reduce the risk of cross-subsidisation by introducing the $20 million subsector caps. There's also been arrangements in place for AFCA to take reasonable steps to try and get the company to pay. There's other kind of safeguards in the design of the ongoing scheme. But what we've got in relation to the upfront levy is a very arbitrary approach to levying the 10 largest organisations, none of whom have unpaid determinations. And we're very concerned about the lack of certainty, which is why we've made the proposal to revert the accumulation recovery date to the previous bill. I should stress that everybody who has an eligibility to get paid under the scheme will get paid, but they'll get paid in a more proper process under the operation of the scheme proper, rather than this very arbitrary upfront levy.
Okay, but your greatest concern is the ongoing or the upfront?
I think that there are equal concerns about both, but in terms of the upfront levy, that is where we have the greatest public policy concerns about both the arbitrariness and the discretion of the scheme operator to essentially pre-capitalise a scheme which is meant to be, event capitalised.
Okay, but sorry, can I just ask one last clarification? So just so I understand, so in terms of the ongoing, if there was a financial advice collapse and phoenixing events and everything else which qualified for there to be an African determination to be made and therefore the scheme be enacted or drawn upon in 5-10 years from now, and it was on such a scale that it did meet the criteria for it to exceed the 20 million cap, would it be your members, the the ADIs that would be subject to paying in that scenario, or would that be other organisations that are actually in the financial advice space?
So it would be at the discretion of the minister, but the way the legislation and the regulations can operate is that the credit subsector, which is generally ADIs, would be could be very heavily exposed to that liability.
Okay, well, if you could just provide anything on notice on how we can limit that risk, that'd be great.
Okay.
Senator Smith, do you have questions?
I do. Thanks very much, Chair. But just very briefly, my first question to the ABA goes to page 2 of their submission and their first point in regards to additional points that should be included. What do you think is the likelihood of the scheme operator requiring public indemnity insurance claims to be pursued in the first instance, which is the first point in your additional points for consideration?
Yeah. So our understanding is that that expectation or requirement is reasonably limited. If you look in the bill, there are certain steps that AFCA needs to take to, I guess, inform the eligibility of the claim, but those steps are quite limited. They include things like discussing with the AFCA member the unpaid determination, providing them with a warning that their AFCA membership will be withdrawn. It doesn't require any kind of legal step from AFCA in terms of getting a default judgment or anything else, or AFCA on behalf of the client pursuing the professional indemnity insurer.
So is your concern that it's discretionary? Because in your submission here, you have emphasised the word require.
Yes. So at the moment, the CSLR operator has a right of subrogation to pursue the PI insurer. Our view is that they should be required to do so unless it is, unlikely or reasonably unlikely that they'll be successful.
So why then does the legislative proposal? Why does the legislative proposal make it discretionary rather than mandatory?
I don't know. I suspect it's because there are costs involved in making any claim, and the legislators may have decided that there should be some discretion for the CSLR operator to weigh those costs up. But we think that should be much more clearly expressed in the bill by making sure that the CSLR operator has an obligation to pursue claims and to make that assessment.
Great, thanks very much. Secondly, in the APRA submission, they make some comments and draw some conclusions from the implementation of the Banking Executive Accountability Regime, the BEAR. I don't know if you've seen their submission. They make 4 points in regards to their observations about how successful the BEAR has been in driving sort of, for want of a better word, cultural change. Perhaps on notice, could you just, if you've not already seen it, just have a look at that APRA submission and advise whether or not you do or do not agree or got any further comments in terms of how they've represented that APRA 2020 report, the implementation of the Banking Executive Accountability Regime?
Yeah. We definitely can. My recollection is that when that report was issued, the banking industry was supportive of the report, but we'll come back to you in more detail. Great.
Okay. Thanks very much. Thanks, Chair.
Thank you very much. And thank you very much, Ms. Cupit, for appearing as a witness today. That's all the questions that we have for you. The committee's agreed that responses to questions on notice should be provided by COB Monday, 17 October. And I'd ask now that you disconnect from the hearing, and you can continue to observe, should you wish to do so, through the live stream on the Parliament's website. Again, thanks very much for coming today.
Thank you.
I now welcome Dr. Andrew Schmulo from the University of Wollongong, who is here with us in person. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. As you take your seat, for the Hansard record, would you please state your full name and the capacity in which you appear today?
Thank you, Senator. My full name is Andrew David Schmulo, and I appear in the capacity of a lecturer and academic in law at the University of Wollongong, specialising in financial regulation.
Thank you. And I now invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask some questions.
Thank you, Madam Chair. I'll get straight into it. The bill in question, the Financial Accountability Regime Bill, is, to say the least, drafted in a manner that makes it difficult to understand. But with the support of two of my colleagues, two leading law academics who specialise in financial regulation, we've unpicked the bill, and I can tell you categorically that what this bill does not do is provide for personal accountability by way of civil penalties or otherwise. Now, that may come as a surprise to you, Madam Chair, in light of the testimony that you've heard here today, for example, from the Financial Services Council. So let me take you to some specific provisions. If you have a look on page 85 of the bill, the note at the bottom of section 83, subsection 3, you will see that it states, section 81 is the only civil penalty provision of this Act that can be contravened by a person other than a body corporate. In other words, section 81 is the only civil penalty provision that can be contravened by a human being. So let's go to section 81 and see what that says. That's on page 82. Section 81 says that a person breaches this section if they contravene a civil penalty provision or they induce the breach of a civil penalty provision. And you will see at the end of subsection 1 the words civil penalty. Those will be helpful in a moment. So the story so far, 83.3 says human beings can only be held liable for a breach of section 81. Section 81 says you can only be held liable if the breach is of a civil penalty provision. So what is a civil penalty provision? Well, if we look to section 79, subsection 2 of the Regulatory Powers Act, you will see a definition of what is a civil penalty provision. A civil penalty provision is a provision that has at its foot either a pecuniary penalty or the words civil penalty. So now let's look at those sections that, for example, the Financial Services Council was referring to this morning. Very good sections, laudable sections, sections that impose all sorts of qualitative duties on an individual. For example, the duty to act with honesty, integrity, due care and skill and diligence, the obligation to take reasonable steps to stamp out misconduct or prevent non-compliance with the law, all of which are admirable. Unfortunately, if you look at the bottom of those sections, you will see that you will not see the words civil penalty, nor will you see a pecuniary penalty. As such, those are not civil penalty provisions, which means that a breach of those provisions is not covered by section 81. Now, at this point, you might say to me, but hang on a minute, these still impose duties on individuals. Duties to act honestly and with integrity, etc. But those duties are not matched by any form of punishment for breach. So what is the value of a provision that is not matched by any form of punishment for breach? That question was answered by Commissioner Hayne in the Banking Royal Commission final report at page 10, he was discussing section 912 subsection 1 paragraph A of the Corporations Act, the duty to act efficiently, honestly and fairly, a provision that has no matching sanction for breach. What Commissioner Haynes said on page 10, and I quote, he said, "As the law now stands, breach of these general obligations carries no penalty." At page 73 of the Royal Commission final report, he provided a remedy. He said, and I quote, "should be enforceable by civil penalty." At page 260 of the Royal Commission final report, he decries the lack of sanction provisions for breaches of the SIS Act, and he said, and I quote, "breaches of SIS attract no consequence." So what happens if you breach section 21 or 22? Well, nothing. Nothing happens. Because section 81 says an individual is only accountable for a breach of a civil penalty provision. At which point perhaps you'll say to me, okay, but what about section 80? Section 80 is pretty good. Section 80 is on page 82 of the draft bill. Section 80 gathers up all of those sections, 20, 21, all of those sections that deal with honestly and fairly and due care and skill and taking reasonable steps, and it makes all of them civil penalty provisions. But if you have a look at section 80, it makes them civil penalty provisions, but only for an entity, not for a person, or not for a human being. At which point perhaps you'll say to me, okay, but what about section 15? Section 15 is on page 18 of the Act. Does the same thing as section 80. Gathers up all of those sections, makes all of them civil penalty provisions. But if you have a look at section 15, the heading is obligations of accountable entities. So it doesn't apply to human beings. So what are the other civil penalty provisions in the Act? What are the other provisions that qualify as civil penalties because they contain the words civil penalty? There's sections like section 44, but again, that only applies to an entity. Section 65, but again, only applies to an entity. Our old friend section 80 only applies to an entity. There are two exceptions. There are two places where civil penalties can lie against an individual. Those are breaches of section 66 subsection 3. And if you have a look at section 66 subsection 3, you will see that it is what I put in to the category of administrivia. So if one of the regulators gives a direction to a director to provide them with a document, for example, and the director fails to provide that document, then they can be levied with a civil penalty up to $10,000. And then, of course, there are breaches under section 81. Those are the breaches where a director himself or herself breaches a civil penalty. So how does this work in practice? Let me illustrate it with a couple of examples. And the examples that I'm going to use, mindful of the strictures that pertain to parliamentary privilege.
And Dr. Shmulo, just for your information, there's a couple of senators who will have questions for you in the time that's allocated, and you might want to start to conclude your opening statement. Okay, thank you.
Let me conclude with an example. These are examples that are on the public record. In case of Austrac versus Westpac for breaching anti-money laundering, counter-terrorism financing laws 23 million times. Directors of Westpac, particularly those on the risk committee, were warned over a period of 6 years by Austrac that Westpac was in danger of breaching anti-money laundering, counter-terrorism financing obligations. They were warned by their auditors, who provided them with red flag reports that Westpac was breaching anti-money laundering, counter-terrorism financing laws. Westpac was found guilty of breaching those laws 23 million times, and to date not a single individual has been held accountable. Could you hold them accountable under this new bill? Well, only if you could show that they personally breached money laundering laws or that they personally directed Westpac to breach money laundering laws. If all they did was receive reports that Westpac was breaching money laundering laws and turned a blind eye, then under this bill, there is nothing that can be done. Thank you.
Thank you very much, Doctor, for those opening statements. I might just kick off with a question and then go to Senator McKim. Your focus is on individual penalties in the financial accountability regime. There are models for these sorts of penalties overseas, and I was wondering if you could talk to us about the UK's senior managers and certification regime, how that works, whether that's a sort of a model that's useful, what the level of success has been with that model in deterring, I guess, the sort of conduct that you've been raising with us today.
Thank you, Senator. The SMCR regime in the United Kingdom imposes not just civil penalty provisions on directors for failing to take reasonable steps to ensure that their organisation is compliant with the law. It goes further, it imposes criminal liability. And that has resulted in some substantial fines against individuals, like, for example, against the CEO of Barclays Bank, who was fined a considerable amount of money for breaching whistleblower legislation. And these provisions that we find in the SMCR in the United Kingdom are part of an international trend. We see that trend emerging in New Zealand, South Africa, Germany, Italy, Spain. And in fact, what we have here is an attempt to buck the trend. I see much consternation at the what I assume is the ABA officers. We see an attempt to buck that trend. And there was a report in the Australian Financial Review that indicated that that trend, that we started to buck that trend thanks to representations made by the banking industry, that senior leaders in the banking industry should not be held personally accountable because various reasons. Well, those various reasons don't seem to have been applicable in other jurisdictions, and the sky hasn't fallen on their heads. And it has led to a more meaningful approach to directorial obligations in those jurisdictions. And it's disappointing to see that in light of the evidence that came out before the Royal Commission of directors who turned a blind eye and who attributed failings, substantial failings, in the case of NAB overcharging $650 million, overcharging fees to customers that were not applicable, that those were attributed to carelessness or administrative oversights or a computer problem or...
Thank you. And just before I go to Senator McKim, you quoted from the Hayne Royal Commission in relation to civil penalties, and I am not aware that the Royal Commission recommended the sort of civil penalties that you're recommending be included in this bill in relation to the financial accountability package. Can you clarify your evidence?
The Royal Commission didn't recommend that there not be civil penalty provisions against individuals. And what the Royal Commission did say, page 341, for example, is that there must be appropriate accountability when misconduct occurs. The Royal Commission recommended the distribution of the BEAR regime to the rest of the financial industry. And that BEAR regime, in my view, had greater accountability measures than the FAR.
But the Royal Commission didn't recommend the civil penalties that you're recommending be included in this bill?
As I say, Senator, the Royal Commission didn't recommend that civil penalties not be introduced. And the international experience in this field is that without civil penalty provisions, without meaningful accountability provisions, there is no discernible impact on directorial behaviour.
Senator McKim.
Thanks, Chair. Can I just confirm that you can hear me okay?
We can.
Thanks very much, and good morning, Dr. Schmuller. Thanks for your submission and your evidence. I also wanted to explore the issue of the lack of civil penalties in regards to the executives that do not take reasonable steps. Could I just ask you first, perhaps I could just have a go at characterising how I understand the FAR and how it does and doesn't apply civil penalties to individuals. So is it correct to say that executives are personally on the hook for a failure to comply with directions from a regulator?
Yes.
Thank you. And executives are also personally on the hook if they, in a sense, deliberately contravene the accountability obligations in Section 81.
Correct.
Thank you. But executives are not personally on the hook for failing to take reasonable steps to run a bank or a super fund or an insurer in a way that doesn't negatively impact consumers. Is that correct?
Not only that, they're not on the hook if they fail to run a bank or an insurer in a manner that is compliant with the law. They're only on the hook if they deliberately direct the entity not to comply with the law.
Thank you. That's very helpful. Now, the whole accountability obligations contained in this legislation are in fact based on the concept of reasonable steps, or in large part at least. Is that correct?
In sections 21 and 22, yes, that is correct, but those sections, there are no consequences for breaches of those sections.
That's right. So, given there are no consequences for breaches of those sections, what do you see in general terms as some of the issues that might arise from this legislation failing to impose those consequences?
Senator, in light of the revelations that came out before the Royal Commission, in light of the fact that no directors of any major financial institution has been held accountable, I think what that does, particularly if that's reinforced by this bill, is it plays into those fears in the community, those tendencies in the community to lose faith in the institutions of government and in government itself. And it leads to the emergence of a narrative that there exists a swamp and that swamp must be drained. If you have a look at the United States and the experience there, the financial industry in the United States, colloquially Wall Street, has engaged in widespread, long-standing and serious misconduct for a very long period of time, and the US Congress has consistently failed to stamp that out. And that gave rise to the emergence of a narrative that there was a swamp, and in so doing, opened the door to a demagogue who promised to drain the swamp. Ironic when you consider he appointed his children to cabinet positions. There is a direct link between the misconduct that took place on Wall Street and the election of possibly the most temperamentally unsound and unqualified individual ever to sit behind the Resolute desk. These are the dangers that happen when you fail to hold people to account. It plays into dark fears and it gives rise to very troubling tendencies that we're seeing elsewhere. And it starts with this bill.
Thank you, Doctor. Can I put this to you? If individuals are not on the hook for failing to take reasonable steps, and if it's just the companies that are on the hook, isn't it the case that penalties just become part of the cost of doing business?
It may become part of the cost of doing business, but in the worst case scenario, it's a cost to the shareholder. And a director who is paid a bonus, where that bonus, or paid a salary, where that is independent of these things, cost to the shareholder is not their problem. It wasn't the problem of the board of directors of Westpac when Westpac paid a $1.3 billion fine for breaching money laundering legislation 23 million times. And in the case of a financial crisis, if it leads to that, it's still not the problem of the director, it becomes the problem of the taxpayer.
In your view, does a failure to impose penalties on executives for failing to take reasonable steps, does that failure increase the likelihood of poor behaviour and potentially criminal behaviour?
Absolutely, and that is where personal accountability regimes began. They began as a reaction to the global financial crisis and to the excessive risk-taking that had been evident before that crisis. The excessive risk-taking, which in the academic literature has come to be called bet the firm behaviour. So directors would pursue short-term profits at the expense of the long-term sustainability of the firm. And where those firms are systemically important, that can precipitate a financial crisis. It's a classic case of moral hazard.
Thank you, Doctor. And forgive me, I was just having a couple of technical difficulties during your opening statement. I think you may have been exploring this during that opening statement, so forgive me if you were, but could I just ask you to summarise the trends internationally in this space and whether by failing to impose penalties for a failure to take reasonable steps on executives, whether we are bucking any kind of international trend here in Australia?
Yes, Senator, there are a number of key developments that have taken place in the United Kingdom, the SMCR regime, which imposes not only civil penalty provisions on directors for failure to take, for example, reasonable steps to ensure that the corporation complies with the law, it also imposes criminal liability. We see the same provisions being reflected in the Conduct of Financial Institutions Bill in South Africa, which I assisted in drafting, and the Conduct of Financial Institutions Bill in New Zealand. We see similar trends in Spain and Italy and Germany and in a number of other jurisdictions. And wherever these regimes have been introduced, the core of that regime is individual accountability, not under all circumstances, not for anything and everything that goes wrong, but where it can be shown that somebody didn't take reasonable steps to stamp out illegal conduct. For example, a member of the board of directors of a bank receives a report from AUSTRAC to say, we think you're breaching anti-money laundering legislation, and does nothing. That would be an example of a failure to take reasonable steps. And I don't think that's unreasonable.
All right, thanks very much, Doctor. Chair, I have no further questions, and thank you, Doctor. Your evidence has been very helpful.
My pleasure.
Yes, thank you very much indeed, Dr. Shmulo. Thank you for appearing as a witness for us today. The committee has agreed that responses to questions on notice should be provided by COB Monday, 17 October. We thank you very much for appearing in person today, and you go with our thanks again. Thank you.
Thank you, Madam Chair. It was my privilege.
I now welcome a few minutes ahead of time by video conference representatives from the Australian Securities and Investments Commission and representatives from the Australian Prudential Regulation Authority. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today?
Yeah, my name's Greg Kirk. I appear for ASIC. I'm Executive Director of Strategy at ASIC.
Rachel Howitt, Senior Executive Leader of the Corporations team at ASIC.
And I'm Stuart Bingham, General Manager of Governance, Culture, Remuneration and Accountability at APRA.
And I'm Peter Sheffield, Head of Accountability at APRA.
Okay, thank you very much. Are there any more representatives from ASIC and APRA there to introduce themselves?
Thank you, Chair. Tim Goff, Senior Executive Leader, Credit and Banking at ASIC.
And Chair, Sarah Edmondson, Senior Executive Leader from the Behavioural Unit at ASIC.
Great. Thank you all very much for being there for us. Do you have an opening statement that you'd like to give?
Chair, on behalf of ASIC, we just wanted to thank you for the opportunity to appear before the committee today. And again, I'd like to congratulate you on your appointment as chair of the committee.
Thank you.
As you know, we have appeared before the committee previously to answer questions on some of this legislation. And today we once again welcome your questions and look forward to answering them. With that, I'll hand to my APRA colleague.
Thanks. I have a brief opening statement on behalf of APRA. So APRA welcomes the opportunity to appear before this committee to assist the inquiry into the Financial Accountability Regime Bill 2022, the FAR Bill. I'm joined today by Peter Sheffield, the Head of Accountability. APRA has made a submission to the inquiry setting out APRA's experience working with the Banking Executive Accountability Regime, the BEAR, and preparatory work undertaken by APRA and ASIC in anticipation of the introduction of the FAR legislation. This submission is similar to the submission made by APRA to the inquiry on the FAR legislation introduced in the last Parliament. As noted in our submission, APRA supports the introduction of the FAR. As the committee is aware, the FAR is to be jointly administered by APRA and ASIC. Accordingly, APRA and ASIC continue to work closely together to prepare for the anticipated implementation of the FAR. This has included work on a joint administration framework and infrastructure to support APRA and ASIC jointly administering the FAR. Both regulators understand the importance of communicating with industry on their requirements. Accordingly, we have planned for industry communication and guidance to be published to support industry with the implementation of and ongoing compliance with the FAR. With these opening remarks, we are happy to take your questions.
Thank you very much. And I would like to kick off with some questions for ASIC about the small amount consumer credit and consumer lease provisions. We haven't yet spoken much about this aspect of the package this morning. The joint submission from Consumer Action Law Centre and a number of consumer groups has detailed examples of consumers being granted loans and leases that are unsuitable to their income. What insight can you share with us about payday lenders and consumer lessors' compliance with responsible lending obligations?
Chair, I might hand that question to Tim Goff, who's best placed from ASIC to deal.
Thank you.
Thank you, Chair. We're very well aware of the concerns that have been brought to the committee's attention by groups such as those that you described. It's fair to say that compliance with responsible lending obligations by small amount credit providers and consumer lessors has been a focus of attention for ASIC for some time and continues to be the focus of our attention. Not all consumers of SACs and consumer lease products are financially vulnerable, but many are, and many obtain these products in order to obtain essential goods and services. I think that means that there is a heightened risk to those consumers in terms of their ability to repay at all, or without falling into financial difficulty, or without having to resort to further high-cost credit. So one of the things that we consider is very helpful in the bill is the overall protected earnings amount. I think what that does is complement responsible lending, which is a principles-based regime with a bright line test, which provides clarity to lenders as much as it does additional protection for consumers.
Okay, thank you. And are you able to outline to the committee, I think this might be for you as well, Mr. Goff, are you able to outline to the committee the sorts of enforcement action that you do take in relation to these sorts of small amount and lease providers?
We've taken enforcement action in relation to those types of entities across a range of issues. There's been a number of instances where we've taken action for failures to comply with responsible lending, but I think it goes beyond responsible lending. There's been action that we've taken where we've seen fees that are prohibited by law being charged, where there have been breaches, in our view, of the cap on cost for SACCS. Work that we've undertaken in relation to advertising and also general avoidance of the regime. We do have some relatively new powers that we're also seeking to exercise. We've issued product intervention orders utilising our product intervention power. We've also been working particularly with SACCS around design and distribution obligations to ensure that target market determinations are doing what they should be doing, and we've certainly seen some improvements in that area, but continue to work with that sector very closely to ensure that TNDs continue to meet the expected standards.
Okay. What are there specific barriers in relation to these sorts of financial entities in terms of enforcement? I mean, do you find that there are particular barriers to effective enforcement in this part of the financial services market?
I think there are probably two sector-specific challenges to enforcement that I'd be happy to highlight. And I think one is around the availability of consumer evidence. We often find that in these areas, consumers can be unwilling to provide evidence to support a case by ASIC. And I think that makes sense given the nature of the transactions involved. Consumers are often vulnerable and not ready, I guess, to have their particular financial circumstances highlighted through the kind of action that ASIC would need to take. But equally, we find that it's often the case that the victims of some of the misconduct that we identify can be in remote or regional communities, so access to some of those consumers as witnesses can be tricky. It's certainly the case, particularly for Indigenous consumers and others maybe from a non-English speaking background. There can be cultural issues and discomfort with participating in court-related processes. But I think the other issue in this sector that can be a barrier to us enforcing or taking enforcement action successfully is around poor systems and record keeping. It's not uncommon in our investigations as we seek to gather evidence of misconduct that we do encounter poor systems and record keeping such that it becomes difficult for us to obtain sufficient information to allow us to assess properly whether a breach of the law has occurred or otherwise progress our work.
Okay. You mentioned just earlier the anti-avoidance provisions in the bill, and you've talked about some of the enforcement problems that you face there with these sorts of entities. What will the anti-avoidance provisions in the bill do to assist with enforcement and with regulation of companies that are, I guess, seeking to evade enforcement activities?
I think, as I said before, avoidance behaviour has been and continues to be a problematic issue for this sector in particular. And on that basis, we certainly welcome the proposed anti-avoidance provisions. I think having the ability to effectively take action in relation to providers who are seeking to avoid the important consumer protections, whether currently in the law or the increased protections as proposed, is critical to the integrity of the regime and to ensure that consumers are not disadvantaged.
Is there a sort of example that you could give us of that, where you've tried to take an enforcement action against someone and they've been able to avoid, and where the anti-avoidance provisions would assist, or if not a specific example, a sort of a type of example of how these companies are currently able to evade effective regulation?
Chair, if you don't mind, I might offer an example rather sort of a general sense of the type of conduct that we anticipate. There will be increased protections and greater limitations on what lenders are able to lend to consumers and what costs they can recoup from those consumers. And I think it's inevitable that some existing participants might turn their mind to how they can maintain the current profit from their existing businesses. And I think what we would expect to see then, in the absence particularly of an effective avoidance provision, would be an attempt to restructure a business such that it no longer appeared to be a small amount credit contract or a consumer lease. And we have seen examples of that type of conduct in the past, where there is an attempt to impose form over substance. And we would not be surprised to see that here, except to the extent that an avoidance provision demonstrates that that would be, I guess, ultimately a futile exercise.
Okay, thank you. That's very helpful. I just want to switch to a question in relation to the CSLR. There were comments made by the Australian Banking Association earlier today, and I don't want to misquote them, and I would have to check the Hansard exactly for the comments that they made, but they were comments to the effect that ASIC is already encouraging people to apply for the CSLR, I think, rather than pursuing the entities that ASIC should be pursuing. I think that was a characterisation of the evidence that they gave. What's ASIC's response to that?
Chair, I might pass to Sarah Edmondson on behalf of ASIC, who's had the carriage of ASIC's input into the development of the legislation.
Thank you, Chair. So I understand that what the ABA was referring to in its evidence was a media release and action that ASIC took in relation to former clients of Dixon Advisory, and we issued a media release about what steps we took in August of this year. And that was to let former clients of Dixon Advisory, which was in administration or is in administration, to let them know that they may need to lodge complaints with AFCA in order to preserve eligibility for a CSLR. We have been in an environment where governments have made a commitment to establishing a CSLR since the recommendations of the FSRC, and as we're aware, legislation was first introduced into Parliament, into the last Parliament in October last year, obviously not passed. So there has been a pretty significant amount of uncertainty for some consumers in terms of the complaints that they have about whether or in what circumstances they might be eligible for compensation in the event that their determinations are not complied with. So ASIC did take steps to let those former clients know that they may wish to lodge complaints with AFCA, as I said, to preserve possible eligibility. We were very clear in the communications that this did not mean that they would, in these cases, people have not even been through an AFCA process. They don't even have an AFCA determination at this point in time. So it was not a statement about expectation about being compensated, but really about preserving eligibility for a scheme that is intended to be established by government.
Thank you. And just one follow-up question on that. And again, I would have to exactly check the Hansard and don't wish to misquote, but I thought there might have been a suggestion that in providing that information to those potential claimants about going to AFCA and preserving their ability to claim later from a future scheme, that may, I thought the implication was somehow be linked to ASIC taking less action today in relation to, as you've now clarified, Dixon Advisory. Is that correct?
No, that's not correct.
So there's no relationship between you providing that advice to individuals and how you exercise your powers in relation to Dixon ongoing?
No, that's right.
Okay. I have a few more questions for both ASIC and APRA in relation to the FAR, but I think I've taken a little bit of time there, and I'm aware that Senator Bragg has some questions. So if you're ready to go, Senator Bragg, you have the call. I think you're on mute, Senator Bragg.
Oh, thanks very much. It goes with the territory, I guess. Now, on the issue of the moral hazard, how do you think this is best going to be managed, given that this is legislation that hasn't been passed by the Parliament? You're already proposing that people should seek redress through this scheme, even where determinations haven't been made. So you're already signalling to the market that you will point people in the direction of AFCA and the scheme. So how on earth are you going to manage this expectation? How on earth will you manage this moral hazard that you're now going to be sitting with?
As I just referred to in the previous answer, what we were advising customers was to consider whether they may have a complaint, and if so, that they may wish to make a complaint with AFCA. Whether someone ultimately gets through to a compensation scheme of last resort is dependent on them, in most cases, firstly, having gone through a firm's internal dispute resolution procedures, then lodging a complaint with AFCA, going through the AFCA procedures, AFCA determining that they have suffered loss because of the misconduct or breach of law by that particular financial firm. So I'm not quite sure how the argument about moral hazard comes in when there is an established framework set up which is set to test whether consumers have a claim for loss in the first place. From our perspective, what the CSLR does is plug a gap for consumers who have established through the processes set up by Parliament that they have a claim for loss, and where that claim has been unpaid because of the failure or insolvency of the particular financial firm.
So you don't accept the characterisation that the establishment of this organisation is going to change anything ASIC will do from a law enforcement perspective?
No, I don't.
But you've already issued...
If I can add to that, we have always, it's long been the case that as provided by Parliament, individual disputes and claims and the determination of them go not to ASIC to resolve, but to AVCA. And we have always encouraged consumers who feel that they have a complaint or a dispute with their entity, that they need to go first to the entity's IDR scheme, and then if they're unhappy with the outcome, that EDR will be available to them. And again, the law provides that the entity has to tell them if they're dissatisfied with their outcome at IDR, that EDR is available and how to apply. So that's something that's provided for by Parliament. ASIC has a different role.
I
It may
understand
arise
that.
from the same
We've
set of
never had a scheme like this before. There's never been a scheme where the Minister of the Day could levy large amounts of money from the industry to effectively recompense customers where there has not been proper law enforcement. I mean, the first obligation of ASIC and regulators is to enforce the law to prevent these things from happening. I mean, what we're doing with this proposed bill is granting enormous power to the minister. Wouldn't you agree?
I agree that ASIC's role is to enforce the law, which is a different role to determining disputes between individual customers and financial services providers. And that ASIC does that. But when ASIC does that, and we get penalties from entities, and in recent years we've got many hundreds of millions of dollars in penalties from entities, that doesn't solve the individual dispute for any individual customer. The penalties don't go to those customers; they go to consolidated revenue. So they're different roles. So in terms of a moral hazard, certainly in terms of ASIC's work, ASIC's work doesn't change just because the individual complainant is compensated, whether directly by the firm or through a compensation scheme of last resort. It's still ASIC's role to take action to enforce the law in appropriate cases and to seek penalties where that's justified.
So what is ASIC going to do in terms of its internal controls to ensure that it doesn't end up in a situation where it's giving advice directly or through its new subsidiaries, which will include AFCA and the compensation scheme? There's not in a position where it's conflicted and it's recommending that the government of the day seek draw funds from the industry where there should have been more substantive law enforcement.
I think the structure of the scheme itself provides barriers. Happening in the sense that, again, as Sarah Edmondson was saying, for any individual consumer to get compensated through the compensation scheme of last resort, they first have to, go to IDR and go through that process. If necessary, go on to an EDR process, have a determination made in their favour, so there's findings that there's been wrongful conduct in relation to them or the at least liability, and then they have to establish that it has to be established that the entity is insolvent and unable to pay. And only then does the scheme
I understand how the law is designed. What I want to see, and maybe you can take on notice, is what risks and controls. So what risk and control framework is ASIC going to have to manage that risk that I just outlined to you verbally? So if you can take that on notice, I'd be grateful. Finally, in terms of the oversight, I mean, I know that you probably do enjoy coming to parliamentary hearings all the time, and we thank you for your time on a regular basis. As you know, under this current arrangement we have, where AFCA is effectively established by an act of parliament, but is not required to appear because it doesn't receive an appropriation. We would now be, if this bill was enacted, supercharging AFCA's role and then creating a significant subsidiary body, which would be shielded from parliamentary scrutiny because, of course, only ASIC appears. Now, what do you think about the idea of these organisations having to appear directly, given they'll have their own boards?
Senator, I think at the end of the day, it's a matter for the government and the parliament as to who they call before it. I might hand to, and I know you've asked us questions on notice about this, and I don't know whether you would like us to go through the existing accountability measures that are in place.
No, I just want the answer to the
questions
question.
on.
I just want the answer to the question I asked, that's all.
And so that you want an opinion from us about whether they should appear before. I think we would say that's a matter for the government and the parliament as to whether they seek to call bodies before it.
Okay, so you're happy to appear on their behalf and take responsibility for them to the parliament?
We're happy to appear and account for our own oversight role set up in the legislation in relation to AFCA, and which will be a similar role in relation to the compensation scheme of last resort.
Okay, well, I mean, I would just say to you that you have a significant conflict of interest. So I look forward to receiving your information. I don't mean you personally, just for avoidance of doubt, but I think the organisations would be conflicted in their establishment in this way. And so I look forward to seeing your information on notice and provide.
Thank you, Senator.
Thank you.
Thanks, Senator Bragg. I'll just ask a couple of questions in relation to the implementation of the FAR, which has been coming in forms for some period of time. You mentioned in your opening statements that ASIC and APRA are working together to prepare to administer the FAR. Can you just give us a bit of an indication of that preparation and how you're thinking of, I guess, streamlining approaches so that regulated entities don't end up with sort of double burdens of approaches of dealing with both of you separately?
Thank you, Senator. I'll take that one first. So the two regulators are working collaboratively and cooperatively with each other in how we approach the joint administration of the FAR, and we have regular engagement with each other at all levels through the organisations, through both at a working level all the way up to commissioner and member level. Shortly after the FAR legislation receives royal assent, we will be issuing documents to industry, which will outline some of the areas of joint administration, but will also outline how we intend to implement the FAR, including some pre-commencement activities to help industry in the implementation of the FAR. But the regulators are ensuring that we maintain clearly defined roles and responsibilities with each other, supported by agreed processes and procedures with appropriately resourced administration teams and training and support for supervisors of both regulators to ensure consistent regulatory approaches. The two other aspects that we're putting in place to help streamline the processes for industry is a single point of contact for entity queries and issues, and then also a single portal for entities to submit their notifications. And the portal will be the APRA Connect system, so that the entities only do that once, and then the regulators will share that information with each other so that we can streamline the administration.
Okay, thank you. I think it was the APRA submission in particular which went to evidence around how the existing BEAR is assisting in transforming the culture of organisations and the way in which you're able to work with them. How do you see the FAR as assisting your work in continuing to transform the culture of the regulated entities and you know, broadly restoring trust in the financial sector?
Thank you, Senator. So I think that the experiences and the benefits that we've got from administering the BEAR, we would see that they would translate equally to the insurance and superannuation sectors. And so things like improved understanding and clarity and transparency around individual accountabilities for individuals within those entities, allowing for sharper and more challenging discussions between boards and their accountable executives, both in preventative actions, but also in remedial actions, and also as the regulator, allowing for more targeted discussions between APRA and going forward ASIC as well, with entities and accountable executives, particularly around remediating issues. These are all the benefits that we see with the BEAR that will definitely translate to FAR with superannuation and insurance.
Okay, thank you. And just a final question from me, and I think it's the final question from senators. I'll just check on that. But do you have an indication of how many entities will be covered by the FAR?
Yes, Chair. So the number of entities currently, excuse me, under the BEAR, it's around 145 entities, and they'll extend with insurance and superannuation to approximately 435 entities. All up will be covered by the FAR across ADI, super and insurance.
Okay. And do you happen to have a breakdown there of the super and insurance?
Not directly in front of me, but it's something happy to provide.
No problems. Thank you. I see that there are no other questions from senators for the regulators. So I thank you very much for appearing as witnesses today. The committee has agreed that responses to questions on notice should be provided by COB Monday, 17th of October. And I'd ask that you now disconnect from the hearing. You can continue to observe the hearing should you wish to do so through the live stream on the Parliament's website. And you go with our thanks. Thank you very much for appearing today.
Thank you, Chair.
Thank you, Chair.
The committee will now take a short break and resume at 11:30 a.m. I now welcome by video conference representatives from Choice and in-person representatives from the Consumer Action Law Centre and the Care Financial Counselling Service. And I think we also have online representation from Consumer Action Law Centre as well. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today? We might start with those in the room first.
My name is Tanya Clark and I'm the Director of Policy and Campaigns at the Consumer Action Law Centre.
I'm Lyndall Milburn and I'm a financial counsellor with Care Financial Counselling Service.
Thank you. And we'll go to those of you appearing online. If you could state your names, perhaps starting with you, Mr. Kirkland.
Apologies, Alan Kirkland, CEO, Choice.
Thank you.
And Patrick Ferre, Head of Policy and Government Relations at Choice.
And Tom Abarisk, I'm a Senior Policy Officer at Consumer Action Law Centre.
Okay, thank you. I now invite you to make opening statements and I might go to Ms. Clark first.
Thank you, Chair. I'd like to start first by acknowledging the traditional owners of the land on which we're all meeting on today. I am here with my colleagues at Parliament House, meeting on the lands of the Ngunnawal people, and I pay my respect to their elders past, present and emerging. Before I begin our opening statement, which I will be talking mainly to the Schedule 4 of the Finance Sector Reform Bill, just wanted to clarify with the committee that Tom Abarisk, who's online, is here to answer any questions relating to the consumer credit reforms being considered, in particular Schedule 4 of the Finance Sector Reform Bill, which I'll call the FSR Bill. And also Patrick Verrett and Alan Kirkland, CEO of Choice, who'll be able to speak to the provisions relating to the compensation scheme of last resort and the financial accountability regime. I'm just going to deliver a brief opening statement, then hand over to Alan Kirkland to deliver a statement in relation to the other bills that I just referred to. So to begin with, we would all like to congratulate the federal government for introducing these bills into Parliament. We put to the committee in relation to Schedule 4 of the FSR bill that these reforms are long overdue and should be passed without delay. We recommend that the committee unanimously recommend to the Senate that these provisions be passed as a matter of priority. We have been calling for the reforms to payday loans and consumer leases since 2016. The FSR bill implements the reforms recommended in the final report of Treasury's 2016 independent review of small amount credit contracts, which is known as the SAC review. The SAC review recommendations, which are reflected in Schedule 4, are, in our view, fit for purpose. We strongly encourage all members of the committee to be guided by the SAC review recommendations in considering Schedule 4. Since the SAC review and over the past 7 years, these products and the harm caused by them has not changed. If anything, they have got worse as financially vulnerable people across Australia are experiencing the pressure of rising interest rates and increases in the cost of living. Payday loans can attract fees equating to an annual interest rate of over 200%, and there is currently no limit on what may be charged under a consumer lease, something that the reforms outlined in Schedule 4 will change. Consumer leases often require people to pay many times the price of the goods across the life of a lease, sometimes up to 8 times more. We have one client that Consumer Action assisted who paid up to $15,000 over the life of her lease for a laptop that was only worth $3,000. Due to the excessively high fees and irresponsible lending practices that we witness, these products commonly breed financial exclusion and almost always leave people we assist worse off. Lyndall, sitting beside me, will be providing evidence today of the harms that she has witnessed her clients experiencing and will be able to outline some of those harms to the committee. Despite industry claims to the contrary, people who need to turn to these products as a temporary measure will still be able to continue to use them. The major difference, if these reforms are passed, will be that the financial harms will be prevented and these products will be safer, fairer and more affordable. So we strongly recommend and support the proposed 10% protected earnings cap amount for both SACs and consumer leases, which will prevent payday lenders and lessors from signing up people in financial difficulty to multiple credit products when they simply can't afford them. We strongly support the introduction of a 4% cost cap on the base price of a good for a consumer lease. The 4% per month amount is consistent with the 48% annual cost rate cap in the National Credit Code that applies to almost all other forms of regulated credit. We strongly support the proposed ban on unsolicited communications by payday lenders. We strongly support the proposed anti-avoidance provisions, which we believe would empower ASIC to effectively prosecute rogue lenders such as Signo, who deliberately rely on complex legal models to avoid regulation altogether and charge consumers excessive fees. Finally, separately from this bill, we think the government should take steps to remove consumer leases from Centrepay. Centrepay is meant to help low-income beneficiary recipients manage essential bills. It shouldn't be used to preference repayment for high-cost credit. This may not require legislation, but rather a genuine effort to update Centrepay policy, and we'll be working on that over the coming months. So thank you. I'll now pass over to Alan Kirkland, CEO of Choice, to finish our opening statement.
Thank you. I will only speak briefly, acknowledging the main focus today is on the small amount credit contract reforms, which we strongly support as well. The other key components of this bill, which address the financial accountability regime and the compensation scheme of last resort, were canvassed by the committee in an inquiry completed earlier this year. But I'd just like to briefly highlight some key areas in which the bill could be improved in relation to those two reforms. On the financial accountability regime, the most important point to make is the lack of any civil penalties attached to accountability obligations under the proposed regime. When the former government or Treasury under the former government first consulted on this reform, it proposed civil penalties of up to $1 million in effect. That would bring the penalties in line with those that apply under the Corporations Act, the ASIC Act, a range of related legislation. And if we don't have civil penalties attached to this regime, it sends a message that the obligations are less important than other legal obligations that apply to financial sector firms and executives. So we think that's an important reform change to bring back as originally proposed. And in relation to the compensation scheme of last resort, I guess I'd say it's our understanding that the establishment of a scheme like this is not a contested issue. It's enjoyed bipartisan support as a concept for some years, as well as strong support from crossbench parties and senators. So really, we'd like to focus on a few potential improvements as well. One is to expand the scope to cover all of the financial products and services that are covered by the Australian Financial Complaints Authority, and the other is to align the compensations caps under this scheme with those that apply when people go to AFCA. Thank you.
Okay, thank you very much for those opening statements. I will kick off with some questions for Ms Milburn, and I understand that Senator McKim will have some questions a little bit later on as well. Ms Milburn, can you just tell us a little bit about what you do and who you work for?
So I'm a financial counsellor with CARE Financial Counselling Services in Canberra. I've been there for 8 years, and the vision of our organisation is financial fairness for all. And these loans, as they're provided now, are not fair for a lot of people. I was previously an accountant, decided life could be a bit more meaningful, and I went back to uni and completed a Masters in Counselling, doing a placement at CARE, and have been there ever since. I'm passionate about working with the people who are victims of this unfair financial system. I work as a housing financial counsellor, and so all of my clients are in public housing, community housing, or are homeless, and the majority of them are on Centrelink benefits.
Okay, thank you. I understand that one of your clients was considering appearing today, and that we're calling her Jane, and I understand that she's decided not to appear, and she's also decided that she'd like a pseudonym used for her today, which we're doing. I'd like to still be able to hear some of the story of Jane. Before we do that, could you tell me a little bit about why you think Jane would find it difficult to appear today and why she might want a different name to be used today?
Sure. So in our submission, on page 8 of our submission, a lot of my clients experience shame and embarrassment around their situations that they've found themselves in. One of our community educators told me people are more likely to talk about their sex life than they are about their finances. And a lot of my job is building rapport with people, helping them to feel that they're not judged, and just making them comfortable to talk about it. So it's really hard to talk about living in poverty. It's really hard to talk about how you make ends meet, let alone when you are forced to take out a lot of these loans, to then admit that, yes, I have taken out these loans, and people can question them and people can judge them, and that's really not fair.
Okay, thank you. Could you tell us a little bit about Jane's story, her example, perhaps, you know, why she took out these loans and how it impacted her?
So Jane really wanted to be here today, but she had some pressing family issues and she was very disappointed that she couldn't come. She is a Wiradjuri woman, a single mother with 2 children, and one has special needs. Her only income at the moment is Centrelink, and she's just recently moving from JobSeeker to carer payment to enable her to better look after her son and not have the pressures of mutual obligations that are required on JobSeeker. She also receives family tax benefit and carers allowance. She lives in public housing, and just last week she was facing the administrative and civil tribunal in ACT facing eviction from her public housing. So she really wanted me to stress that she wants these loans to be available to people, but they have to be at an affordable amount. So when unexpected things happen, people get desperate and they just need to meet some of these costs, and that's the circumstances that have faced her. So at the moment she has 7 payday loans and 1 Signo loan. So the Signo loans lie outside of the regulations. And while she was on JobSeeker, that would have taken up 64% of her income. Another 25% of her income on rent leaves 11% of her income to live on. And that, when she's just on JobSeeker with family tax and carers allowance, leaves her $150 a fortnight to live on. So that's food, utilities, cars, kids, everything. Now that she has moved to carer payment, which was an initiative by her, she will now have $384 a fortnight to live on. So what it's come down to is she doesn't pay these loans because she can't afford them. She has got these loans for, she got a $400 loan to take her son to a paediatrician. He's the only paediatrician in Canberra that can deal with her son's special needs, and she felt she had no choice. And I think it is completely natural for parents to put their children's needs first. She had a few loans related to car servicing, car repairs, tyres, regos, windscreen. And when you're a mother of 2 children, perhaps trying to work part-time, your car breaks down, what are your alternatives? So all of my clients are very resilient and show a lot of initiative in getting through in situations that I think we would all struggle with, but they are very financially vulnerable. And these products are just too easy to get. With one lot of loans, she got 4 loans within 40 days. And they were for car services, car insurance, and that paediatrician appointment. When I get the documents from the loans to see how they've assessed people's suitability for the loans, and in those 4 loans that were taken out in 40 days, there was certainly a lot of inconsistencies. So they are required to list the number of SACs that they've had in the last 90 days, and this varied between those 4 loans, so it wasn't consistent at all. They had her food bills as $85 a week. This is for a woman with 2 young boys, and she describes her youngest son as having a bottomless pit when it comes to hunger. So she tries to give them quality food, fresh fruit, fresh vegetables, and some meat. But that's all become much less affordable for her. The trouble with these loans is that even though they can't be taken out of people's Centrelink, they are direct debited out of people's account as soon as their pay hits it. So they get their money first, and then the people have whatever's left over. And they would make people sign up to direct debited agreements when they take the loans out. So she has actually stopped some of them and is not paying these because they're simply unaffordable to her. Other instances where people have had loans have been the need to travel for family reasons, including funerals. I have one gentleman who borrowed money for pet costs, and I've recently been to a presentation talking about how important pets are in people's well-being, so that they're actually a human being's health issue. You know, all of these new regulations around desexing and everything just add costs to people. I've also had people borrow money, as Tanya talked about, for laptops for study, for electronic goods for their children with all the on-learning environments. So there's a lot of things, there's a wide variety of why people borrow this money.
Mm. It strikes me as you're telling Jane's story that she's taken these loans out for the absolute essentials of living, and that these loans might sometimes be marketed as buying something extra, or buying household goods and so on that might be extra. Is it your experience that you're generally seeing people using these loans and leases to actually meet their essential costs of living?
Yes, I don't find people use them on frivolous things.
Right. Is there a typical kind of person that you see who takes out these sorts of loans?
Sure. So keeping in mind that all of my clients are in public housing, community housing or homeless, obviously all of my clients are in that situation. 40% of my clients have these payday loans, and I didn't look at consumer leases, but they are equally damaging. These people are very resilient, but they're very financially vulnerable. Typical person that I see is on Centrelink benefits, which is just not enough money to meet not only everyday living expenses, but these unexpected costs that come up. So car breaks down, you've got to get to work. What do? And there's just no capacity for people to save money to meet these unexpected costs. A family member dies in Western Australia. What do? And their need for money is right now. The funeral's next week. What am I going to do? And what concerns me about these loans is that people go into them unaware of the full costs of them. So they might see that, and I think the advertising is really misleading. So I know on television they talk about just nimble it. And so I asked my client how easy was it to get these loans, and her response is easiest in a click of a finger. You apply online, they ask for your income, she provides Centrelink income statements and pay slips if she's working, and this client does work when she can. But then the money's in their account, but there's no upfront clear explanation of the costs of these loans. And when people realise it, there's a lot of shame, embarrassment around it. Often these people are unheard people in our society, I think. Sometimes the working poor, and certainly the people that live on Centrelink benefits. Some of these lenders, they're really friendly, You can become a platinum member of Cash Converters, and people kind of feel a bit honoured by that, and they're just misleading. And I have a lot of respect for these people. If you're able to live on any Centrelink benefit, you're a much better budgeter than I am. They're resilient. As I say, they show initiative, and these products are available. So Jane told me when she got her last loan, the company actually rang her because she applied online and they weren't sure, so they rang her, and she talked to them and they gave her the money. That was the 7th loan that she had at that one time. And she was amazed that they gave her the money. With those 7 loans that she has at the moment, the repayments, if she were to be making those repayments, is $877 a fortnight. Right. And she's on Centrelink with 2 children, one with special needs. The harms that she has experienced is certainly around her mental health. You've got 7 loans, you've got them texting you, ringing you, emailing you, your payment's late, we're going to charge you more. So sometimes they can charge people $25 for a missed payment. If a payment is dishonoured, the bank will charge them a dishonour fee, and so the costs just increase. I have seen her going into her own shell and just closing down. And people don't open mail, they become scared to answer their phone because they don't know who's on the other end. She certainly felt that she was paying more than she could afford and that they should not have given her the loans, and not having enough money to live on. As I said, she was facing eviction from public housing, and she told me she often struggles to put food on the table. We also talked about the increased cost of living, and she told me that the packet of sausages that she was paying $20 for are now $26. She's changed where she shops, going to the markets in the hope of getting cheaper meat. And she, as I say, insists on good quality food for her children. So she's not a person that eats, steak every night. She doesn't have high expectations, but she wants to give her children the best. And with these loans, it's just impossible. So just one example of a loan. One loan she borrowed $250, and the total loan, the cost of the loan is $463. And she already had 5 payday loans before they gave her that. On the 23rd of December, she borrowed $500 with repayments of $213 a fortnight, and that loan for $250 was given 4 days later. So once people have 2 payday loans, it's assumed that any more would put them into financial hardship. So she already had 4 when she took out the $500. 4 days later, wanting to borrow $250, how is that not financial hardship,
You mentioned before some of the marketing associated with these loans. Is there evidence from your clients of them being sought out by payday lenders and them direct marketing to them?
Absolutely. So I have seen one client, as soon as they paid off one loan, get nice, happy, cheerful emails. Congratulations, you're now a platinum client. You can borrow more. Come and talk to us and we'll give you more money. I've also seen, which really appalled me recently, but I believe that it is legal, but I believe this changes would change it, is somebody applied for a loan with one payday lender, was knocked back because it was unaffordable. Within 24 hours, she had offers from other payday lenders. If it's unaffordable for one, how can it be affordable from another payday lender, which would have exactly the same conditions? And the fact then that they have shared information, we're not prepared to take the risk to lend to this person, but maybe you are. And I think that's just appalling. These people are very financially vulnerable, and as evidenced, borrowing $250, it can make a difference, but it's got to be affordable. And Jane certainly wanted to say, at times she needs these loans and she wants them to be available, but they've got to be affordable for her.
Yep. Okay. I think it's so important, Ms Milburn, that we have this evidence as we're considering this legislation, and that we really hear the stories of people who've been affected by these practices. And I'd really like you to convey to Jane our thanks for allowing you to share her story. I might just ask Ms Clark, before I hand over to you, Senator McKim, given the evidence that you've heard there from Ms Milburn, what are the most important provisions of this bill that will assist with some of the really horrendous examples of predatory lending that she's told us about today?
I think the ones that I've outlined in the opening statement, particularly the 10% protected earnings cap amount for both payday loans and consumer leases, that will actually, in our view, encourage more responsible lending and avoid those situations that Lyndall's outlined in the multiple products and people just taking on too much debt that they've been aggressively sold and marketed to.
Thank you. And I think I've taken up a fair amount of time there, and we might go to you, Senator McKim.
Thanks, Chair. So my questions, I think in the first instance, are probably to Choice and maybe to you to start with, Mr Kirkland, and it's around the issue that you flagged in your opening comments, which is the failure of the FAR bill to provide for penalties for individuals who breach their accountability obligations. Can I just start by asking what you think of what you think are the implications of that failure of the FAR bill to provide for penalties for individuals who fail to breach their accountability obligations?
If there are no civil penalties attached to these obligations, that stands in stark relief to the other obligations that individuals and firms have through the various other legislation that applies to financial services. So it essentially says the Parliament doesn't consider these obligations to be as important as other obligations, and you should treat them as such. Individual penalties are a really powerful motivator to drive compliance with the law. We've seen that in a range of other areas. Workplace health and safety laws is one of the best examples. I think there's well-established evidence that for people in leadership roles in organisations to be individually liable has driven a significant improvement in compliance with those laws. It's also a matter of aligning the law with community expectations. When we survey Australians, 90% of people think that executives should face fines where they break the law. And obviously, that's not going to be the case if the bill goes through as proposed. We're, of course, not arguing that that regulators would need to seek civil penalties in every case. It's a matter of simply having them as part of the regulatory toolbox or the enforcement toolbox. So you've got a graduated range of penalties that can apply, including those that are already in the bill. And just the prospect of individual penalties and their occasional use will actually be a really powerful motivator in driving compliance with the law.
Thank you. Do you think there's a risk that if individuals are not on the hook for failing to meet their accountability obligations and it's just the companies that are on the hook, do you think there's a risk that companies will just regard having breaches as a cost of doing business, and that they'll just factor that into to the way they operate, and that would be different if in fact individuals were able to be held accountable through penalties?
We've repeatedly seen that if you don't get penalties at the right level, then they are treated as a cost of doing business. And in some cases, companies are able to insure for those costs. Otherwise, they're simply absorbed into their overall cost structure. And what you need in order to drive strong behaviour in the interest of customers in the financial sector is penalties that apply at the firm level with financial consequences, reputational consequences, where regulators seek those penalties in court, but also individual consequences for the people that have actually played leadership positions and overseen where harm has occurred to consumers. Now, obviously, we're hoping we're not going to see that in that many cases, but where there is evidence of serious harm and that has happened under somebody's watch and they've been an active participant, there should be individual consequences.
Thank you. And can I put this to you? Well, I'll ask you this: Does the failure of the FAR bill to include penalties for individuals who fail to meet their accountability mechanisms, does that failure, in your view, make it more likely that executives actually will fail to meet their accountability obligations?
I do think it's more likely that we'll see more cases of executives failing to meet their accountability obligations because the individual consequences will be limited.
Thank you. That's really helpful, Mr. Kirkland. I wanted to just give the Consumer Action Law Centre an opportunity to respond to any of those questions I've just asked Mr. Kirkland, if you wish.
Thanks, Senator. I think that Choice have probably covered off on everything. They've sort of led our work on this, but yeah, strongly endorse Mr. Kirkland's comments.
All right, thanks very much. Thank you, Chair. That's very helpful.
Thank you. I might just go back to Mr. Aburisk for some further comments in relation to payday lending and consumer leases. Just reflecting on the evidence that Ms. Milburn gave and the story about Jane. I wonder if you can talk to us about the advertising and canvassing reforms in the bill, and what your understanding is of the need for those sorts of reforms, given the types of aggressive marketing that were just described to us here.
Yeah, thank you, Chair. Look, absolutely happy to talk to that. So those examples that Ms Milburn was talking about in regard to emails and text messages that past users of payday loans receive regularly, that's a classic tactic that we see used to sort of push people towards obtaining more high-cost finance at a time when they really don't necessarily need it. You know, as Tanya said, we're talking about loans that can come with equivalent annual interest rates of up to 200%. The only time you should ever even possibly consider that sort of thing, and I should say that I don't think that there'd ever be a situation a financial counsellor would suggest that someone would take one of these out, but is only at a point of crisis. And so this idea that payday lenders use your details once you've signed up with them to send you a suggestion once you've paid off one or when you're about to pay off one, that you should take another out it's completely inappropriate. It's very predatory, and so there's a provision in the bill that would address this. It would ban unsolicited communications to past users of payday loans. So that would make a huge difference. It would mean that they can't start aggressively marketing these products after they've been at a point when the consumer isn't necessarily looking for one. In terms of consumer leases as well, look, there's a few really shocking practices that we've seen in the consumer lease space for a number of years. One of them is door-to-door sales, often as a result of referrals from other clients. So I've seen consumer lease providers who will get involved, particularly in, say, remote communities or communities where where English isn't their first language, and use referrals to try and sign people up, offer discounts to existing customers, and then they'll just show up on people's doorsteps with offers of products. Door-to-door sales have been shown to lead to really shocking outcomes in virtually every sort of industry that they've been used in and that they've been reviewed in, and consumer leases are the same. So there's a ban on canvassing of consumer leases. So essentially it would mean that you can't show up to someone's house, you can't sell them in public as well. Doesn't mean that consumer lease providers can't do what they like in store, but it would mean that those door-to-door sales would be stopped. The other issue that was raised during the 2016 SAC review, and there's certainly been recent evidence that it's continuing in the consumer lease space, is particularly in remote Aboriginal communities. There's a few consumer lease providers on a barbecue. They offer people goods on the spot. They show them the goods. They offer them their sort of attractive per week or per fortnight price that they can pay for them. Consumers don't realise they're signing up to pay that for 4 years, 3 years, really long amounts of time that mean that they'll pay 4 or 5 times the value of the good. That would also be stopped. So there's a provision in the bill as well that addresses, selling in public. And that's been a really shocking exercise. In some of the worst cases, I think there was a recent ABC article on this. The consumers weren't actually receiving the goods when they signed up to them. So not only did they sign up to a credit product that was supposed to be paying back what they had obtained, it would take weeks, months before they actually obtained the goods as well. So they're sort of some of the big issues that this bill would go to stop.
Thank you. And are you in a position to tell us a bit more about consumer leases, which we haven't had a lot of evidence on yet today? Why do people take out consumer leases? How are they sort of broadly structured? Why are caps important in relation to consumer leases?
Yeah, absolutely. So consumer leases, I guess one of the big reasons that people are attracted to them, again, is through advertising. Most consumer lease websites you go onto have a whole range of household goods that they say you can own for paying, a very low weekly or fortnightly amount. What's often not mentioned in these products, in the advertisements for these products, is that these payments go on for years. It never equates up, it might say it in the contract, but it never equates until you get to that very fine print at the point of signing, the fact that you are going to pay 2 or 3 times the value of the good. Consumer leases also, I mean, theoretically, you, or at least the way that these products are advertised to consumers is that you pay for these goods and you will own them at the end of the lease. That's not actually true. Consumer leases are designed so that you lease the good, and at the end, the provider has the option to gift you the product, or sometimes they gift a family member the product rather than the lessee. Sorry, but there's actually no right to own those products. So, in a broad way, that the understanding of them it's a very complex issue. It's an unnecessary complex legal arrangement. And you have companies like Rent for Keeps, which, you know, the name strongly suggests you're going to get that good for forever, but you certainly don't necessarily. One of the big issues that we see in this space is that, as I said, people pay multiple times the value of the good over the life of a lease. What this bill would do to address that is introduce a 4% per month cost cap, which we anticipate would be calculated on the recommended retail price of the good. Should be worth mentioning, I guess, that you're calculating that on a recommended retail price. That would normally involve a significant markup on the wholesale price. But even so, we're supportive of this cap because none exist at present. It would make a significant dent. We still see leases that people are paying, you know, right up to right now, where they're paying well over that 4% rate. And it means that within 2 years, you're leasing a product for 2 years and you're paying 3 times the price of the good, 4 times the price of the good, which is, in our view, completely unconscionable. Particularly considering consumer lessors can arrange for these payments to go through Centrepay, which is supposed to be a budgeting tool for people who receive income from Centrelink.
Okay, thank you. And perhaps just a final question for Ms. Milburn. Ms. Clark said in her opening statements and Consumer Action Law Centre's submission would like to see the reforms go further and prevent people being able to have deductions from their Centrelink payments. You're dealing with people who are on Centrelink. Would you like to talk to us about the need for that in your view?
Absolutely. I think payments through Centrelink are really vital for people because they get things that need to be paid out of their money before they receive their money. So rent, there's a rent deduction scheme that my clients use for public housing. They can pay utilities, but these rental consumer leases, it's just appalling that they can have access to people's Centrelink money. I'll just give an example. This is my phone. It's worth about $800. I went on the Rent the Roo site this morning. You can buy it for only $29 a week. Who can't afford $29 a week? Over 3 years, it would cost $4,524. So, and that's just not disclosed to people. They get that taken out of their Centrelink, and it's just appalling. I think that Centrelink deductions should be available for essential items, not high-cost credit products.
Okay. I don't believe that Senator McKim has any more questions for these witnesses. And again, Ms. Milburn in particular, if the other witnesses don't mind me saying, I think your evidence today has been so helpful to hear these stories from the coal face, to share Jane's story and the stories of so many other people to the Senate Economics Legislation Committee has been extremely valuable. So in particular, we thank you for your evidence and we thank all of the witnesses for this part of the hearing for your evidence as well today. For those of you who are online, we invite you to now disconnect. And if you'd like to continue, you can continue watching the proceedings on the live stream. And for those of you who are here today, again, we thank you very much for your time. You go with our thanks.
Thank you.
Thank you, Chair.
I now welcome by video conference representatives from the Australian Financial Complaints Authority. by video conference. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today?
Yes, good afternoon, Senator. My name is David Locke. I'm the Chief Executive Officer and Chief Ombudsman at AFCA, the Australian Financial Complaints Authority, and I'm joined by my colleague Justin Untersteiner, who is the Chief Operating Officer at AFCA.
Okay, thank you. I think for the benefit of Hansard, Mr. Untersteiner, if you could just say your name yourself as well. Thank you.
Of course. Justin Untersteiner, Chief Operating Officer at AFCA.
Great. Thank you very much, both, for being there. I now invite you to make a short opening statement if you would like. And at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Thank you. I will make a short opening statement. We welcome the opportunity to provide evidence to the committee today. As the committee are aware, AFCA is an industry ombudsman scheme providing an independent external dispute resolution service to consumers and small business owners who are in dispute with a financial firm. We are not a government agency. We are a not-for-profit organisation limited by guarantee and funded by the industry. Our role is to help the parties to resolve their complaints. We're impartial and do not act for either party. If a complaint does not resolve between the parties, then our role is to make a determination on what we believe to be fair in all the circumstances of the case. Only about 7% of matters that go through to that final decision stage or determination stage. The vast majority of complaints that are brought to AFCA are resolved between the parties through our processes, through conciliation, negotiation, mediation, and investigation. We've had a very high take-up of our services since we were established just under 4 years ago and have already resolved more than 280,000 complaints that Australians have had with their financial firms. AFCA applies the law set by Parliament and the regulatory guidance issued by the regulators. We work closely with Treasury and the financial regulators to ensure alignment because we know that all parties need to understand how AFCA will handle particular types of matters if they come to us. As the committee is aware, we have already responded to questions on notice prior to this hearing, but we've heard questions today regarding AFCA's potential appearance before Senate estimates or other parliamentary committees. I would like to, for the record, state that AFCA is always very happy to attend any parliamentary committee hearings and to account for our work, our decisions and our performance. Since we started on the 1st of November 2018, we've appeared before 9 parliamentary committees, and we believe that it is a really important part of our transparency and accountability that we are accountable to Parliament and that we are subject to scrutiny and to questioning. We are unclear, however, about how appearing before Senate estimates would work, given that AFCA is not actually a government agency. But we recognise that is a matter for Parliament and the government, and we're more than happy to appear before any parliamentary scrutiny that Parliament decides. The bills being considered by the committee will establish a scheme that will provide compensation where a final determination has been issued by AFCA and that remains unpaid, and the determination relates to a financial product or service that is within the scope of the scheme. And many matters, of course, would be outside the scope of the scheme. Although the design and scope of the scheme are matters for government, AFCA does support the creation of a compensation scheme of last resort, and we do believe that its establishment will support confidence in the financial system's dispute resolution framework and the financial sector more broadly. We thank you for the opportunity to appear today, and Justin and myself are happy to answer any questions that you may have. Okay,
thank you very much, Mr. Locke. I'll just kick off with a few questions. You started in your opening statement with some statistics about how complaints are resolved.
Yes.
And I'd just like to make sure that that's broken down and that I can understand that a little bit further. Is there a way of describing how many of the complaints that you receive end up with a specific determination that compensation is owed, and then after that, is there a way of breaking down how many of those determinations are unpaid?
Yeah, yes, there is, Senator. So if we look at the last financial year, 2021 to 2022, we resolved 71,152 complaints during that financial year. 73% of those were resolved by agreement, whereby the consumer and the financial firm were happy with the resolution. That may have been, it could be compensation, it could be being exited from particular contractual arrangements, it could be an apology, it could be a range of resolutions really. But 73% resolved in that way. What we have is 7% of matters, so just under 5,000 cases went through to an ombudsman or a panel for a determination. So that is the 7% that I referenced at the start, and that is the number that go through. If we look at those determinations, the vast majority of those are complied with, and the financial firm, if, for example, compensation is awarded, the financial firm has 30 days in which to comply with the determination. If we look at the matters that went to determination, those 5,000, what we would find is that 24% of those were found in favour of the consumer, and the remainder were found in favour of the financial firm. So you are looking at 24% of 5,000 are determinations that have gone in favour of consumers. Of course, many, many more matters have been resolved, often with payments to consumers at earlier stages in the process. If we then look at the matters that are unpaid, I'll pass to Mr. Untersteiner, who can give some more details to you about the unpaid determinations that we already have on our books. And also, Senator, I think the committee may be interested in the other matters that we have currently paused because of the financial firm going into insolvency. So these will be cases where complaints have been brought to AFCA, and then we've been notified that the financial firm is insolvent, so we've paused those consideration of those cases. But I'll pass to him now.
So in terms of the process that we have in place, as Mr. Locke has alluded to, if we receive a matter and the firm is insolvent, we will not undertake, at the moment, we don't undertake further work on that case, we pause it. And we've been doing that, waiting to see the outcome of the compensation scheme of last resort. And that's a long-standing sort of policy of the organisation. What we have on our books at the moment are total compensation amounts against those open and paused claims of $662 million. And in terms of cases where we found in favour of a complainant, a determination was issued and then the firm went into insolvency, we have a further $14 million in compensation that is outstanding. Now, that doesn't mean, and this is really important, that doesn't mean that those are all potentially in scope of the compensation scheme of last resort. If we look at our analysis at the moment of what that would look like against the current scope of the compensation scheme of last resort, we currently have open complaints against insolvent firms that we believe prima facie to be in scope, 1,880 complaints with total compensation sought. And this is really important to say that this is just what the consumer has sought. We haven't yet undertaken any investigation, right? So This is purely just a figure that's been put into a form from a consumer and doesn't take into consideration caps or jurisdiction. But just to give you an idea of scale, it's $357 million in compensation sought. Separately,
Sorry, what was that figure? 357 million?
Correct, correct. Separately, we have completed investigations against 35 matters with a total compensation of $4.7 million, and that's where, after making that determination, the firm went into insolvency. I will just say, I think it's important to highlight too that of those open complaints, the $357 million, that has been a moving figure. One of the key drivers has been Dixon Advisory going into voluntary administration. And so of the 1,883 complaints and the $357 million, 1,720 of those are against Dixon Advisory, and $332 million of that compensation is against Dixon Advisory. So that is absolutely the material component of those amounts.
Okay. Thank you for that.
So those matters have not been assessed by AFCA. We haven't determined whether there is any liability. Those are just matters that on the face of the legislation would fall within scope of the scheme and would need to go through the process and be considered. So the only matters that we have already made determinations on where we found misconduct or liability and there are unpaid amounts and would be within scope at 35 complaints, which is, as Mr. Untersteiner said, amount to 4.7 million. And that's 306 consumers involved in that. The rest are matters that are on our books at the moment that are paused, that would go through the AFCA process, and we would need to really consider the conduct of the parties. We'd really need to consider whether there was any breach of the law. We'd really need to consider whether the sums that were being claimed, whether anything was due, or if it was due, what amount of compensation was reasonable. So those figures with regard to the work on hand are very much, this is what the consumer says on the face of it, but no investigation work has been done, Senator, to assess that at this stage. But that is the potential liability, as has been said, and the vast bulk of that are the Dixon matters that have come to AFCA not more recently.
Okay, thank you. There's been some sort of commentary in the hearings today about the measures that are available to AFCA to try to pursue these sorts of claims. Are you able to talk us through the proactive measures that AFCA currently uses to get compensation paid? Perhaps in the case of companies before you're aware of an insolvency, and then perhaps after you are aware of an insolvency.
Yeah, I can take that. So at the moment, under the AFCA rules and under the legislation, AFCA doesn't have a proactive role in pursuing debts against financial firms. So our role typically finishes once we've issued the determination. In saying that though, where we have a consumer advise us that compensation hasn't been paid, we would engage with the financial firm to identify why that might be the case. And separately to that, then we would, if there is still no payment made, we would report that matter to ASIC, and it becomes a matter then for ASIC to pursue. And I guess the key, one of the key levers that ASIC do have is if a licence holder doesn't pay a determination, ASIC would have the ability to remove their licence.
Right. So all of your measures are essentially, mediating between consumers and the entities that are covered.
Yes. Our role is to mediate, to try and resolve the matters, and if we can't, to make a determination. If that determination is then accepted by the consumer, then the member is contractually obliged, as a result of their contract with AFCA, to comply with that determination. If they don't comply with the determination, we become aware that they haven't complied with the determination, then it is to the conduct regulator to enforce. We notify them as soon as we become aware that there may be an issue with that. And so that is really how we've been set up and how our rules operate.
Yep. Given your experience over the last few years, are you able to give us an insight into how an industry-funded compensation scheme of last resort would have the potential to assist consumers and also improve culture in the sector?
Yeah. Well, we see issues very often when things have gone badly wrong. It may be that there's been serious misconduct, or there's been criminal activity that's been conducted by the financial firm. We will find we have to not only look at individual matters, but also identify if we see systemic issues or serious contraventions of the law. And we have a whole regime that requires us to report those through to regulators. And certainly that is work that we do. Where we have got determinations that have been made against consumers, particularly in the financial advice sector, which is largely what we are looking at really with regard to the compensation scheme, it may be that the person has lost very significant funds. It may be they've lost all their life savings as a result of the conduct of the financial firm. And so many of the situations we see are people who are in real hardship and distress, who have done nothing wrong. They have gone through the process with the financial firm. They've then come through to AFCA. We have independently looked at all the documentation and all the matter. We've made a finding in their favour, and then that hasn't been honoured. And so it does cause significant distress and significant hardship to people where that is the case. A lot of the work that we do, of course, is with the banks and insurers, prudentially regulated bodies where we don't see this. We have, compliance and those determinations are paid, and that's how the scheme should work. But certainly where we do see these insolvencies problems, the stories can be pretty heartbreaking.
The bill provides for an industry funded levy in a couple of ways, in an ongoing way, and also in relation to the backlog of unfunded determinations that may be there. Are you able to describe to us where AFCA is at in estimating the value of the backlog of unfunded determinations, and what your role is in relation to that?
Yes, sure, Senator. So the answer is that we, at the moment, our role has been a relatively small one, in that we provide data that has come through the complaints to Treasury, for Treasury to do that modelling. Now, as we mentioned before, we are yet to investigate most of those open complaints. So the 1,800 odd complaints I mentioned, we haven't yet investigated. And really, to determine the true liability, we have to undertake that investigation, and that will take some time to do, because there are a significant number of complaints there. And so at this stage, our role is not to determine what the levy will be for industry. That is the role of Treasury. So what we do instead is we provide the data that we have available about the claim amounts, and then they undertake their own actuarial estimates, So I do think that might be a question for Treasury about how they are undertaking that assessment.
Okay. And in terms of the harm that can be caused that was described by Mr. Locke when you see these sorts of unfunded determinations, is it your view that the legislation should, if possible, proceed fairly quickly to create the compensation scheme and make it available to those people that you've been dealing with?
It is, absolutely, Senator. We strongly welcome the legislation and would encourage the committee to recommend its early passage.
Okay. On that note, I understand that there are no other questions from other senators, and I'm just putting the call out there and understand that it's a case that there are no questions from other senators. So I thank you both very much for appearing before the committee today. The committee's agreed that responses to questions on notice should be provided by COB Monday, 17 October 2022. I would ask that you now disconnect from the hearing and you can continue to observe, should you wish to do so, through the live stream on the Parliament's website. Thank you very much.
Thank you so much.
We'll just take a very short 1 or 2 minute break while Treasury comes to the table a little bit ahead of schedule and just check that we have everyone from Treasury who's appearing. Yep. Okay. I now welcome representatives from the Department of the Treasury. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today?
Thanks, Chair. Mahita Zahid is Acting First Assistant Secretary for the Financial System Division.
Rob Preston, Assistant Secretary for the Banking, Insurance and Credit Branch.
Daniel McAuliffe, Director of the Consumer Credit Unit in the Financial System Division.
And Heath Hudson, Acting Director, Redress Unit, Financial System Division.
Thank you. I now invite you to make a short opening statement if you have one.
We don't have an opening statement.
You don't have one. Okay. Thank you very much. And I will start with a few questions for you. I'll start with the small amount credit and consumer lease provisions of the bill. We've had some commentary today that there are consumers out there who, despite having been in very vulnerable situations, would like to know that they can continue to access this sort of finance. So my question is, will consumers still be able to access these types of credits if the bill is passed?
Yes, they will be still able to access credit. It's the bills are about ensuring appropriate safeguards and affordability, not removing the ability for consumers to access these forms of credit.
Okay. The 2016 SAC review made a number of recommendations to improve consumer protections and prevent consumer detriment stemming from SACs and consumer leases. Are you able to share some of the examples of the impacts that these products can have on consumers, particularly vulnerable consumers that we're trying to address with these bills, with this bill?
Yeah, happy to, Senator. So the 2016 review identified a number of harms that these bills would be addressing. So currently, the review identified that people can end up having multiple forms of these small amount credit contracts or consumer leases, which can build up and enable debt spirals to occur, which lead them to be in a financially vulnerable position. The review identified that these forms of credit are often very high cost. At the moment, there are no limits at all in terms of the consumer lease and the costs that can be involved with those. So, like the review identified that an extreme example with a consumer lease, sometimes the cost when you look at the total repayments over the scope of a lease could be 8 times the cost of the product in question. ASIC conduct regular surveys to identify levels of stress among users of these sorts of products. So 28% of consumer leases, users of consumer leases, and 34% of users of SACS have 2 or more identifiers of financial stress as measured by the HILDA or Household Income and Labour Dynamics survey, and that compares to 8% for credit card users. So that's just a sort of an overview of some of the sort of forms of hardship that people can find themselves in, and these reforms would help to address.
Thank you. How do the government's changes to SACS or proposed changes to SACS and payday loans enhance consumer protections?
Sure. So the reforms, well, I might just run through a number of the reforms and provide some commentary on what they'll be doing. So when it comes to SACS, currently in terms of affordability, people using SACS who have more than 50% of their gross 50% of their gross income coming from Centrelink are limited to having no more than 20% of that income being directed to SACS repayments. This bill would change that such that all users of SACS can have no more than 10% of their net income being contributed to SACS repayments, and that would ensure that that an appropriate amount of their income is being directed to SACS repayments and preventing people from entering financial hardship. Another example in terms of how hardship would be prevented by these reforms is preventing unsolicited offers for people to take up a SACS loan. So I think you heard some evidence today from other participants in the hearing, but in the 2016 review, there were examples provided of people receiving unsolicited SMS messages in order to encourage them to roll over or take up a new loan when a loan might be expiring, or take on a loan in the lead up to an event like Christmas, and the bill would prevent that from occurring. In terms of consumer leases, the bill has a number of changes. As I mentioned earlier, currently the cost of consumer leases are uncapped, and so what the bill would introduce is a capping arrangement whereby the lease could not have a cost of more than 4% per month, plus the base cost of repaying the base cost of the amount in question, with the 4% per month capped at a maximum of 192% after, which is a four-year loan amount. So that reduces the total amount of the cost of a product under a consumer lease arrangement. In addition, the same provision that I referred to earlier in terms of the amount, the affordability protection in terms of capping it at 10% of an individual's net income is also applied to consumer leases. So there are a number of other provisions, but they're probably, in terms of preventing harms, a few of the highlights.
Yep. You've been through some of the key provisions there and how they will assist in protecting some of the consumers that we heard about in the earlier evidence today. The committee also has submissions from providers of small amount consumer credit in particular, who say that the bill could have some negative impacts on consumers as they sort of respond to the bill. What would you say about that evidence?
Sure. Well, in a way, going back to one of your, perhaps I think it was your first question, the bill isn't preventing use of these products, but more limiting them to being used appropriately. So, so when it comes to, say, access to consumer leases, for an adult who is on the base rate of JobSeeker, receiving no rent assistance, no other payments, they would still be able to lease a fridge, a washing machine, microwave and a dryer all at the same time. So it's sort of not, it's not the case that it's going to make one of the common uses to which a consumer lease is being put completely unavailable to a core, I guess, consumer group who use these products. I think it's fair to observe, though, that that there will be changes required within the sector in response to these provisions, but we don't see that it would be something that would be well, going back to, sorry, I'll just focus on the question. In terms of consumer harms, some of the evidence that was put in submissions was talking about people moving to other forms of credit. Mm-hmm. So, for example, and an example is Buy Now, Pay Later. Yeah. So, Buy Now, Pay Later exists within exemptions within the Credit Act, but being able to fit within those exemptions themselves have caps on what Buy Now, Pay Later providers are able to do. So they're not allowed to charge interests, and the fees are capped at, I think, $250 in the first year. 200 in the first year and 125. Thank you, 200 in the first year, 125 in the second year. So my observation is going to the point that it's unlikely to be the case that people who currently are using very high credit would be made worse off, because one of the forms of alternative credit is actually, in most instances, likely to be more affordable than the SACS and consumer lease that is being affected by these provisions in this bill.
Okay. You've mentioned there in your evidence some examples of predatory lending practices that were identified in the 2016 review, unsolicited marketing behaviours, lack of affordability. We've had evidence today of credit providers perhaps not doing effective sort of diligence when they are offering loans to people, sort of a range of problems that have been identified. Are you able to give us some insight into how the anti-avoidance provisions may assist in the enforcement?
I might turn to my colleague, Mr. McAuliffe.
Yeah, certainly. I think there's two ways this bill will help with compliance. So the first one is, I'll deal with the anti-avoidance second. The first one is that it actually also revises the sanctions and penalties, not only for the new provisions in the bill, but for some of the existing provisions in the bill. That will help deal with deterring some of that conduct that has perhaps been referred to in earlier testimony. In addition to sanctions, there's also now provisions where credit providers can actually lose their entitlement to fees if they breach various provisions. So there's that aspect there that's all about increasing deterrence and improving standards of conduct. Then in terms of the anti-avoidance activity, so there's now a broad in the bill, there's a broad anti-avoidance provision that is being provided for, and so that is specifically directed at activities where people are trying to avoid the operation of small amount credit contract laws and consumer lease laws, either in full or part. It will complement past reforms such as the product intervention powers, which are actively being used by the regulator at the moment to try and address some of these concerning business models. And again, the idea is that there has been what can be sort of a whack-a-mole response to some of these models, where there is a regulatory response to prevent certain business models, and then some of these operators change their business models. I think the financial counselling sector in particular has been quite frustrated with some of these models, considering their concerns about harm, particularly to vulnerable cohorts, and this more general principle-based anti-avoidance provision hopefully will be a very effective tool in dealing with some of that conduct.
Thank you. I have a couple of questions about other parts of the package, but I will go now to you, Senator McKim, who was visible to me a moment ago. There you are. Senator McKim.
Thank you, Chair, much appreciated. And thanks to Treasury officials for making themselves available today. I wanted to ask questions around the failure of the financial accountability regime legislation to provide for penalties for individuals who breach their accountability requirements. And I'd just like to start by acknowledging that the proposal paper released by Treasury in 2020 said that individuals will be subject to civil penalties for breaches of their accountability obligations. And just to ask Treasury folks whether you could explain how we got to a situation where Treasury's proposal paper said that individuals would be subject to civil penalties for breaches of accountability obligations, to legislation now where individuals are not subject to any penalty for breaching their accountability obligations.
Thanks, Senator McKim. I might take that one. So, as you referenced, the consultation paper raised a broad set of proposals that were for consultation, and Treasury undertook extensive consultation on that. Kind of going back to where this came from, where the recommendations came from, Commissioner Hayne had recommended in his report that the banking executive accountability regime be extended and it apply to other APRA-regulated sectors. Now, the BEAR, as you've already heard from a number of people who've provided evidence before me, does not include individual civil penalties. Once we had undertaken the consultation, the exposure draft legislation that was released for consultation did not include individual civil penalties, and obviously the formal version of the bill also did not include individual civil penalties, which is consistent with the bill that we've got before you today. There's a number of reasons. So there's a number of deterrents that's already put into the legislation as it relates to individual accountable persons within these entities. There's deferred remuneration obligations. There's the ability to have to be banned from being able to be an accountable person. They're reasonably and quite punitive and serious penalty provisions. They're not civil penalties, but they are mechanisms to ensure where an accountable person fails to undertake their role or fails to take reasonable steps to undertake their role, they are subject to recriminations. There's a number of concerns that were raised when individual civil penalties were consulted on, and again, some of that you've already heard in submissions. Some of that is you've got very different size players in the market when you look at the APRA-regulated entities that are subject to the FAR regime. the individual civil penalty regime would impose significant individual civil penalties on some accountable persons who don't actually get a huge amount of remuneration through these boards. The implication of that on thinking through attracting talent to the sector, especially at the smaller end of the financial services sector, is one that was raised with Treasury. There's also other implications in terms of what it means for how entities approach and how individuals within those entities that are accountable approach their obligations. What the bill intends to do is require accountable executives and those that are decision makers in the financial services sector to take their role seriously, to do all reasonable things necessary to ensure their entity is complying with the law. You want to balance that out against an overly conservative and simply, legalistic tick box approach to governing financial services entities. So it's those concerns that were raised, but ultimately what is the case is it is implementing the recommendations of Commissioner Hayne, which was to introduce and extend the BEAR to other APRA-regulated entities and ensure that it was joint administration through ASIC. So the bill does, I guess, exactly what Commissioner Hayne had recommended.
All right, could you take on notice, please, which organisations made representations to Treasury through responses to the proposal paper in 2020, to which organisations made representations to Treasury asking that the civil penalties should be dropped?
Senator, I'm happy to kind of take that on notice, but I'll flag that it was most segments of industry that raised that.
That doesn't surprise me in the slightest.
No. So I think I don't have the numbers off the top of my head. We held a number of roundtables, but it was an overwhelming kind of point that came through. It is a very broad regime. We're extending ASIC having co-regulatory role in this is something very new. So it was from memory, and I am now drawing back to quite a long while ago, as you say, it was a very broad view represented across different segments of the industry.
Yeah, it doesn't surprise me in the slightest that the people to whom these penalties would apply, if they did exist, didn't want those penalties to actually exist. It doesn't surprise me in the slightest that there was a broad view of industry, and that's exactly the problem that we're dealing with here. Can I ask, just take that as a comment, please, not a question. Do you agree that the inclusion of civil penalties would actually reduce the likelihood of banks, insurers and super funds ripping off their customers?
Senator, so I think it's there's lots of civil penalties already within the frameworks of the Corporations Act, which applies to most of these entities, and the other acts that applies. So it's not clear to us that there is a lack of penalties that are available, and that actually individual civil penalties in and of itself would alter the balance of taking appropriate actions. APRA, who's been administering the BEAR without individual civil penalties, has seen material improvement with the sheer fact of having to have individuals held accountable for particular functions. That sharpens the mind and focus of senior executives. The deferred remuneration levers that are in the proposals are quite significant, and the ability to be banned, and a number of executives would undoubtedly tell you that even APRA taking an action or ASIC taking an action to ban you would actually have a very long-term impact on your employability in the sector. So I think, can I say that having individual civil penalties would in and of itself be a material increase in deterrent? It's hard to say, because we've actually got legislation elsewhere outside of the FAR with significant civil penalties. So it's a little bit of an academic point at this point.
Well, I don't agree, but regardless of that, would you accept that the notion of an accountable person taking reasonable steps is central to the accountability obligations created in this bill?
Yes, absolutely. That's how those accountability obligations are framed within the legislation.
Yeah, yeah. And is it your evidence then that if civil penalties for individuals did apply, that would not increase the likelihood of them taking those reasonable steps?
So I'm just saying I'm not in a position to gauge whether or to what extent that it would apply. I mean, would it include more lawyers in the process? Undoubtedly. Would that necessarily result in a better set of business decisions or better outcomes for consumers and investors and customers? That's the bit that you kind of go, well, there's lots of other civil penalty provisions if that's, the incrementalism is what I'm questioning.
Well, consumer advocates have been very clear in their evidence today, abundantly clear, no hedging or talking around the subject. They've been just very clear that consumers would benefit. Experts in the field have been very clear in their evidence today that it would be not having civil penalties for individuals who fail to meet their accountability obligations will actually significantly weaken the likelihood of them obeying in a lawful way and not ripping off their customers. Can I ask you, are you aware of any recent moves in comparable jurisdictions around the world in relation to this? We've had evidence that there are many jurisdictions comparable to Australia who are moving in the direction of or have imposed recently civil penalties regimes for individuals. Are you aware of that? And would you accept the proposition that if we go ahead with this legislation without having civil penalties for people who fail to meet their accountability obligations, Australia will be an international laggard in this field?
Senator, off the top of my head, I can't recall recent movements. I know the UK obviously have a regime, an accountable persons regime. My recollection is that does have penalties. They've got a very different regime. They also have regulators, in some senses, vetting executives before they take office. So they've got a very different regime to the one that this bill proposes. Off the top of my head, I cannot recall, unless any of my colleagues can, of any other jurisdictions that's made a recent moves. But accountability regimes similar to the BEAR and the FAR, we're not unique in that. There are other jurisdictions that has it. I just don't have the international comparator in front of me.
Okay. Look, back to the consultation process and the subsequent iterations of the bill that you mentioned earlier. You've said that the first draft release, my apologies, the first release of draft legislation did not have civil penalties in it. Can you just remind me when that was released?
The exposure draft was from July to August of 2021.
Okay. And was that, was there a consultation on that exposure draft?
Yes, there was.
Okay, and when did that consultation conclude?
I think you had the date.
The 13th of August 2021.
Thank you. Were there any other exposure drafts released?
We consulted on a consequential amendments and transitional provisions legislation. So that was the consequential changes from 2nd of September to the 17th of September in 2021.
All right, thank you. And then when we went through, obviously, quite recently, a change of government, was the bill as it was in the July 2021 exposure draft, was that just simply put up to government in that form?
So the bill was introduced into Parliament in October 2021 previously. So it was previously introduced, obviously Parliament prorogued. So the bill that's been introduced is substantively the same as the version that was previously introduced into Parliament.
Yeah, no, thank you. I'm aware of that. My question is more to when and if so, whether and if so, when and how this bill was put up to the new minister, and whether it was put up to the new minister with or without civil penalties for individuals who failed to meet their accountability obligations.
Senator, in ordinarily how Treasury briefs ministers, we brief the minister on the legislation, the history of it, issues, and then the bill has been introduced as a decision of government.
Okay. Are there any technical reasons why civil penalties were dropped from the FAR?
So technical, you mean from a legislative drafting perspective, or?
Yeah, or legislative drafting, or any sort of legal?
No, so that's a
issues?
policy decision that was taken in drafting the exposure draft, and obviously a policy decision that's been retained in the bill that was previously introduced and the bill that has now been introduced again.
So it's a policy decision of the new government to introduce legislation that does not include penalties for individuals who breach their accountability mechanism.
Yes, there's no legal reasons why individual civil penalties could not be introduced that I'm aware of. It is the case that it was both the decision of this government and the former government to not introduce a piece of legislation with individual civil penalties.
All right, thank you. And last question from me, Chair. You said earlier that part of the intent of this legislation was to make sure that people took their role seriously, and that that to the greatest degree possible, it ensured that they complied with the law. I'm probably paraphrasing you slightly here, but that's, in my view, more or less what you said, or certainly the intent of what you said. Are you saying that is it your evidence that if this bill did include penalties for individuals who fail to meet their accountability obligations, that would actually not increase the likelihood of those things happening? That is, that they would take their role seriously and that they would comply with the law.
No, Senator, I don't think I'm suggesting that including individual civil penalties would not further sharpen the mind, or in some senses, detract from a senior executive or an accountable person taking their role seriously. I guess your earlier question was framed in to what extent would it, increase them doing so, or enhance, a senior executive or an accountable person taking their role seriously. My previous answer just referred to the fact that you've already got other deterrents in the legislation, so the incrementalism with having individual civil penalties is harder to quantify. I'm not anyway suggesting that individual civil penalties aren't, a strong focus of, it doesn't lead to strong focusing of the mind of the obligations. The point was just more that you've got other things in the bill that already seeks to do that.
No, okay, thank you. So accepting that there are some other things in this bill and in other acts, would you agree that if penalties for individuals who fail to meet their accountability obligations were included in this legislation, would that increase the likelihood that they would take their role seriously and that they would comply with the law?
I'm sure it would have. It would have it would increase the likelihood. I just don't know by how much. It's hard to kind of gauge. Is it a lot? Is it a little bit? How much more do you get with individual civil penalties, and what are the trade-offs? And when government looks at it and when you're weighing it up, you're looking at, it focuses the mind. It includes additional costs into the system in terms of the legal costs that, everyone kind of wraps their head around. And other kind of costs that comes in, insurance costs, that kind of being able to attract talent. So you're balancing out those trade-offs, and you're making a decision, obviously, between that further enhancing the deterrence against the cost that imposes. And obviously government's taken a particular decision. It's up to the committee to think about how you trade off those consequences.
Senator McKim, there's just a few more questions to be asked. Are you concluded, or do you need a little bit more time?
No, I'm done. Thanks, Chair.
Okay, thank you very much, Senator McKim. I've just got a couple of questions about the CSLR. First of all, we've had some commentary today about the industry levy. And can Treasury tell us what the basis is for applying a one-off levy on the largest financial institutions to deal with the AFCA backlog?
Sure. So the one-off levy ensures that the scheme, in terms of the backlog, is industry funded, and as part of the Ramsay review, industry funding was a kind of a key recommendation of that review, and so in terms of the choice of who would fund that backlog, the application of the one-off levy reflects the fact that with the top 10 firms, there's an ability and a capacity to pay for that sector. So it's appropriate to direct the costs in their direction. The CSLR was also a recommendation of the Hayne Royal Commission, which uncovered significant misconduct within the financial sector, and that some of that misconduct came from some very large firms within the sector. So the application of the top 10 levy also reflects some of the historical misconduct within the sector.
Right, so in a sense, the fact that this legislation has been delayed a few years from the Hayne Royal Commission findings seems to have had the effect of separating out the proposal to have the levy be paid by the 10 largest financial institutions who did have sort of findings made about them in the Hayne Royal Commission. And so I think your evidence is that the levy should be taken as part of the findings of the Royal Commission, albeit that it's been delayed to some extent.
Look, I wouldn't want to go as far as saying it's part of the findings of the Commission. As far as I'm aware, I don't think the Commission made recommendations as to who should pay for historical misconduct. It's more just an observation that it was just more drawing that link between, there's a question of, as I said, the Ramsay review was clear that it should be an industry-funded approach. This reflects that it's the industry is causing the harm that is being picked up through a compensation scheme of last resort. And then it's a question of within the financial sector who has the wherewithal to pick up the tab, if you like.
Okay, thank you. There's been a term used in some of the submissions and evidence today in relation to the CSLR, which is this term moral hazard. And I think the sort of the assumption contained in that is that the bill may encourage some financial services entities to sort of offer bad advice or bad products on the basis of there being a new safety net available in terms of a safety net of last resort. Are you sort of persuaded by those arguments, or are there other structures in place that deal with that sort of potential behaviour?
When I'm not personally persuaded by those arguments, and I might, but perhaps more importantly, the Ramsay review itself was not persuaded by those arguments. They didn't. There was a discussion. I mean, moral hazard, as a concept, relates to when there's the existence of compensation or insurance. People may take on more risk on the basis that the costs of failure are picked up. The review looked into this and felt that it could not substantiate evidence of that occurring. When you think about, and I guess there's maybe two dimensions through which you could see it happen. One is maybe the firms take on more risky behaviour. But the CSLR provision has some quite significant sanctions for firms that that would be picked up. So there's an ability to cancel a firm's AFSL or credit licence, and so there's a significant sanction for that. So it's unclear why a firm would want to expose itself greater to what would be kind of an existential sanction in that dimension. But in terms of the another avenue, though, perhaps is for consumers. Would they be seeking to take on more riskier investments? Is another proposition. But again, the compensation scheme of last resort is not about whether or not an investment goes bad. It's about the conduct of a financial sector entity, and so So we just can't see a consumer wanting to take on a more risky investment, because that by itself won't lead to a greater chance of compensation. It's rather in the event that say through mis-selling or in the example of advice, an advisor not taking proper account of the individual circumstance, that would be something that might lead to compensation, but that's not in the control of the consumer.
Chair, can I just add to that? Also heard a couple of other lines of questioning around moral hazard from different perspectives, including the role that the regulator has and the incentives that ASIC may have to pursue enforcement. I mean, in some senses, we wouldn't see that as a moral hazard. So ASIC undertaking enforcement activity against a financial services firm or not does not change the entitlements that consumers have to compensation. So if ASIC chooses, the existing of the CSLR and ASIC's decisions to enforce against a particular financial firms, it doesn't create that sort of a risk that ASIC is sitting there going, I'm not going to take action now because there's compensation. The other thing that is really relevant in terms of the moral hazard is which categories of financial services are included within the scope. So the CSLR covers financial advice, intermediation through credit brokers, it doesn't cover risky investment. So a person who goes to a financial advisor is not going, I'm going to go to a dodgy financial advisor because if they give me bad advice, there's a CSLR which is capped at 150,000. So that argument, if you work through its logical steps, is a real struggle. Now, the other thing that got mentioned in an earlier hearing was phoenixing activity. So what if a firm folds because they've got compensation, can they come back into the system and phoenix? Now, if, for example, again, take a financial advice example, a firm who had a number of complaints in AFCA decides, I'm not going to pay it, I'm just going to hand back my FSL, and somehow we're able to obtain another licence, they're still paying for those compensations because it's an industry-funded scheme. So they're then back into the pool of entities that are now paying for the cost of those entities that's gone out. So the incentive to phoenix, unless you're phoenixing in a very different regulated activity, it's not apparent that it's amplifying that. And then, so, you've got different, people think of moral hazard in lots of different ways, but it's just hard to see how that exacerbates the risk in the system. And we've got a number of other things that's been enacted in the last several years around design and distribution obligations, product intervention powers, things that are trying to make the system safer as a whole. So it's a real kind of challenge to figure out how the regime increases moral hazard.
Thank you for that. I've just got a final question, which I will pose and see how you go at answering it, which is...
Not filling us with confidence.
Well, it's really just about consultation. A standard thing that we would ask is what the consultation has been, of course. Aspects of this package have been around for a very long time. There have been many reviews, Senate hearings, consultations. I'm doing quite well at keeping us to time. So I'm nervous to ask you this question about how you would characterise the consultation around this package, or how you would take us through the consultation that has occurred around this package.
Well, I think we've covered the consultation that occurred in relation to the FAR bill. So there was so perhaps we'll take that as read. I might start at a high level and throw to Mr. McAuliffe when it comes to SACS. So there was obviously the review of the SACS and consumer lease in 2016. There was I haven't turned. Do you have the consultation dates in front of you?
No, I don't.
So there was the bill has been. There was an exposure a bill for that and it was then introduced in 20.
I can go through it.
Oh, you do have the dates?
Yeah.
Right.
Oh, I have the years.
Thank you.
So the SACS, the Schedule 4 of the bill, has actually been subject to extensive consultation, as some of the financial councillors have raised. It's actually been around for quite a long time. So apart from the 2016 SACS review, there was public consultations on a 2017 version of the bill in 2017. And then there was public consultations on the previous government's 2020 version of the bill, again in early 2020. After its introduction, the 2020 bill was also referred to the Senate Economics Legislation Committee and consulted on in that context. Given that level of consultation and that I think the views of all the stakeholders are extremely well known by that stage, there wasn't a separate consultation on the text of Schedule 4 to cover the revisions from the 2020 version of the bill.
And I might just add to that the changes between the bill that the previous government had introduced and the one that's in front of the committee now I would characterise as generally moving the package back towards what the original review was, and so views on that were very well known, and in addition picking up some additional sort of information with the passage of time, such as engaging with the regulator. So in terms of the need for consultation, it was I would contend that it's well known what the sort of views of the key provisions were. I might turn to Mr. Hudson, who can talk to us about the consultation around the CSLR.
Sure. Thanks, Rob. Chair, so with respect to the compensation scheme of last resort, as you mentioned, it has been around for quite a while. It does have its origins in the Ramsay Review Supplementary Final Report, which was made and published in 2017. Following that process, there was a round of consultation on the basis of a discussion paper in December 2019, which was released at that time, for a period of public consultation in 2020, in January to February of that year. And we've received over 40 submissions with respect to that process. And a range of consultations, roundtables were held there too. And with respect to the original exposure draft bills that were released for consultation last year, as Mr. Preston noted earlier, they were released in July for 4 weeks consultation, which concluded on the 13th of August, and also received quite a lot of interest, where Treasury received 65 submissions and where we conducted 7 roundtables and around 10 bilateral meetings with stakeholders as part of that process.
And Chair, that's obviously notwithstanding these are all excluding the Schedule 4 recommendations of the Royal Commission. So there was obviously a process to get to this, the recommendations before all of this consultation happened.
Excellent. Thank you very much. That concludes my questions for you. And thank you for appearing as witnesses today. Committee has agreed that responses to questions on notice should be provided by COB Monday, 17 October. And that concludes today's hearing. Thank you to all witnesses who appeared and to Hansard and Broadcasting for their assistance. The committee stands adjourned. Thank you all.